So we're going to now go into the first topic of the night, which is a simple one, the Second Amendment. So in the first major Second Amendment ruling in more than a decade, the court said that law-abiding Americans have a right to carry handguns outside the home for self-defense. The majority opinion, authored by Thomas, struck down a long-standing New York law requiring a special need to carry a weapon and put at risk similar laws in Maryland, California, New Jersey, Hawaii, and Massachusetts. What do you guys think of the Supreme Court ruling? I'm going to start with the founder of the Piss Court.
Thanks, Dylan. So for those of you who are not aware, New York had a law which was stylized as a may issue licensing scheme having to do with publicly carrying, I think it's a concealed carry actually, license outside of the home.
I don't know this guy's politics at all.
The question was before the
idea.
Supreme Court, which hasn't really dealt with a lot of Second Amendment issues since District of Columbia v. Heller and McDonald, two cases, the pivotal Second Amendment cases in 2008 or 9 and 2010, and really was sort of getting at the scope of the Second Amendment and to what extent the Second Amendment applies to carrying weapons, handguns especially, outside of the home, and what sort of things the government's allowed to do with gun regulations generally. Now, I'm going to start with a disclaimer saying that I'm not some person who thinks it's an important policy objective for us to ban all guns or to do a lot of those crazy, I consider them crazy politically, and I think most of the country does as well, legislative objectives that Democrats have. But just because that's not my priority in terms of legislation doesn't mean that I can't call out hypocrisy when I see it. And I think that this opinion seems very results oriented, and an aberration really from what the Supreme Court has done in the past. One, I think its application of the rule for what kind of legislation is okay, what kind of regulation for guns is acceptable. Because keep in mind, this opinion does not say that all gun regulation is not acceptable. But what it applies for a rule is only those rules, only those laws, only those regulations that are historically founded are those that will be allowed to survive. And I don't think that our Supreme Court precedent and with respect to other protections the Constitution offers is anything near as narrow as that. It's a very exacting standard. Think about the Equal Protection Clause for one instance. Imagine that the government had a new way of discriminating against citizens, and you'd never seen it before. Is it really the case that the Equal Protection Clause only covers those things which were sort of envisioned at the time of its passage in the 1860s? I think it's hypocritical for the court to, in light of the Dobbs opinion overturning Roe v. Wade, to use history in the way it does. For Dobbs, and overturning Roe v. Wade, it's really relevant for the court that there were all these laws that were regulating abortion through the 19th century and the turn of the 20th century. But now it's not relevant at all that this Sullivan Act in New York was established in 1910 or something like that. It's not relevant at all the laws regulating guns publicly in the 19th century. And so ultimately I think that this is an instance of the court going way beyond where it needs to and imposing a higher standard with respect to gun rights than it would even for the First Amendment. And so on that basis, I think the opinion is highly results oriented, and but it's strongly protective of gun rights.
I'm going to throw now over to Sprouticus.
All right, I think first off, I guess everyone wake up.
One last thing. Just
go ahead.
Opening statements under a minute max. Just throwing it out there. Okay.
Yeah. Everyone wake up. It's time to wake up. The lawyer's done talking. No,
Sick
I think the Supreme Court made a great decision with this one. I don't think you should have to. I don't think you should have to prove that you have a reason to use self-defense in order to have the capability to use self-defense. Because most of the time when you have to use self-defense, you don't realize it prior to, and so that's why I say that you shouldn't have to submit to the government a reason why you would need to use self-defense to try and get that ability. In any ways, I think the Supreme Court made the correct decision in this case, and I'm looking forward to other opinions.
Throwing it over now to More Perfect Union.
Yeah. The Supreme Court got it right for a couple of different reasons, and Pisca would have you kind of run down the rabbit hole a little bit. Essentially, what they said is that the show or may show created a situation where people in New York, they had to go provide some kind of an elevated reason or justification over what some other people did. So it created an imbalance, which is expressly prohibited by the 14th Amendment. So the fact that, and people will say, well, what about these rights, these other rights, these implied rights and things of that nature? But the Second Amendment is actually codified out. And I'm going to be probably one of the people people are going to say is kind of crazy. But I think the National Firearms Act of 1934, I think the Gun Control Act of 1968 were both, I think they're unconstitutional because I take a pretty hardline originalist view that the Second Amendment says may not, when it says shall not be abridged, that is an express commandment not to violate this. And for people who say that, well, times change, society, grows
well-regulated militia, motherfucker.
We need to be able to, we need to be able to respond. That's great. We have Article 5, right? Go ahead and amend the Constitution. Get 2/3 of the House and Senate together. You can make it happen, and you can get 38 states until we put, D.C. or Puerto Rico in. You can get 38 states to agree with you, and then sure, you can have any damn thing you want. You can call the sky purple if you want, but use the damn document that we have because that's the fundamental basis of our law.
Okay, now I'm going to throw it over to Jeb.
Yeah, I mean, I generally agree that this is a good decision, and I disagree with the idea that they're holding it up to a different standard. In fact, I think they were pointing out that this law itself held the Second Amendment to a different standard to any other right by, like Clarence Thomas said, I think he drafted the majority opinion on this. Like he said, by forcing people to express proper cause to the government before they have access to a right enumerated in the Constitution. And I know the argument against it, right, is, well, the Constitution does allow you the right to keep and bear arms, but when it comes to carrying them around in public places, that might be different. But it still doesn't justify the proper cause need. That doesn't really appear in many other cases in many other points in the law. And it's essentially saying, well, yes, we are saying that you do have the right in some cases to carry a firearm in public. You basically, the right is just completely up to the discrimination of the state, which I do think is a fundamental violation of both the intent and the written language of the Second Amendment, being that it is to control and curb government tyranny. Why would the government have sole discretion to give or not to give concealed carry permits? So that's my general feeling on the ruling, but excited to see what other people have to say.
Okay, next is Kevin Logan.
Yeah, I'm going to disagree with the previous couple of contributors. I think this is a genuinely terrible decision, albeit it's just building on the previous terrible decision in 2008 in the Heller case, which essentially made up this new individualist right to own a gun in basically the situations you want to, forgetting of course that there is the well-regulated militia element of the Second Amendment, which right-wingers seem to basically fucking ignore. There are a couple of main issues I have with it. Firstly, the very same people who will argue, for instance, that states' rights are really important, are essentially cheering on the fact that the Supreme Court is now saying to New York and these various other states that they don't have the right to do these things in a way that they would never allow for various other different topics. American gun culture is getting significantly worse, and legal decisions like this are not helping in that matter.
Okay, now I'm going to throw it over to Ginger.
Okay, for me, from a constitutional perspective, I don't think that there's a problem with the court ruling. It has been long interpreted through a contextualization strategy to fundamentally guarantee the right of people, or the right for people, citizens in the U.S. to own guns. Although that you can, I do generally believe myself that I wish that there was within the constitutional rights requirements that could be held for owning a gun. If there were some way to do that, then that would be great without ruining people's constitutional rights.
Okay, now I'm going to throw it over to Franklin.
Hey there. So I think we need to talk about the hijacking of the Constitution by the originalists. So a long time ago, maybe 200 years ago. I don't know what the U.S. is, but over 200 years ago, there were these founding fathers, and they had some ideas. But also, there's some history, and the history isn't very consistent. But you can look to very specific founding fathers, and you can pull out exactly what they meant at a given time, because Scalia did it one time. Now, if you read the dissent in Heller, you can also look at another originalist interpretation of the Constitution, and it's kind of a which one do you like situation. I think that it was run with, and now that we have Heller and then MacDonald, you kind of have this sprawling right that seems to incorporate both self-defense and the idea of this broad defensive tyranny that hasn't really been articulated very well. I think that Scalia expanded the right by, or actually retracted the right, through his arbitrary definitions of felons not being able to have gun rights and people with mental illness not being able to have gun rights, and a variety of other things he added that don't seem to be consistent across the board with what was interpreted at the time, but during that 200-year period, they did accept. So all of that is a bunch of gobbledygook, but we're going to get into it when it comes to whether or not this is a good decision in itself. I think if you take the previous decision and apply those factors, then this seems like a logical outcome.
Which is what I said.
And finally, the most important contributor for today's show, Banks.
Yes, thank you. I have very strong opinions about this top. I'm sorry, I zoned out. Whatever the fuck Franklin was talking about. Guns. Yes or no? Should you kill people with a gun? Should you pick a more honorable weapon like the sword or nunchucks or a butter knife? These are all things that
memes,
hotly debated over the centuries. But that's what debate's for. That's what discourse is for, and that's what we're all going to find out about this topic. So I'm excited.
That was nothing.
Thank you, Banks. Now we're going to open it up for a general discussion. Does anyone want to start us off?
I think you... Go ahead, bro.
To what MPU said about taking out the NFA, I think the NFA should be abolished and should be replaced with something that is not placed against the classes. Right now, the NFA is in place, and it is against the classes. The lower class, the lower middle class, and even sometimes the middle class can't afford to buy the weapons that are mentioned in the NFA, while the upper middle class and the upper class can, and it's no problem to them. The only thing the NFA is doing right now is blocking people who have less material wealth to actually buy these guns. That's the only thing the NFA is doing, besides the more stringent background checks, which I don't disagree with. Do the more stringent background checks for the lower class people, but don't charge them. Just do the more stringent background check and then let them receive their weapon. This shouldn't be a controversial statement.
But you think it's unconstitutional? You think it's unconstitutional? Is that clear, Spartacus? You think that regulation is unconstitutional?
I want to clarify one thing real quick. In my opening, I said NFA 1934, which is the original Federal Firearms Restriction Act. So are you talking about the most recent bill that was passed?
I'm talking about the NFA in general. It's always been a charge. It's always been a high. It's always been a high price on the tax stamp.
Right, but the original reason for the National Firearms Act was it came about right after the St. Valentine's Day.
Who cares? As enforced, is there some material difference between the two that you think?
Well, hang on. No, its primary purpose was to regulate or limit the people's ability to buy automatic weapons. Because
who cares about the purpose? You guys are just giving policy reasons. This is the problem I have with a lot of your arguments. Is you guys aren't doing the analysis. You can tell it's disingenuous.
So let me answer. Before you call me disingenuous, let me answer your question.
The arguments are disingenuous.
Let me answer your question. No, I don't think it's unconstitutional. I think it's constitutional to regulate firearms. I don't think it's unconstitutional to regulate firearms. No.
To the extent that MPU thinks it's unconstitutional, I hear all these references to policy reasons. The government shouldn't have this. It's bad for poor people, or it's unfair.
Well, I come back to those words. I come back to those words in the Second Amendment.
Clarence Thomas explicitly is saying that we're not doing this means test and important balancing, that kind of thing. What he's saying is look to history. But all I hear from you guys is not history; it's policy.
I
No,
mean,
the
he
history-
mentioned, I want to move more into this conversation because while the NFA is a whole other conversation, I want to talk more about the decision they made on the New York firearms regulation that we're talking about. And Clarence Thomas did look back to history, but he also did look at as far as like equal application of the law that we see with other constitutional rights. Are we going, like Kevin Logan said, we care about states' rights, but not when it comes to guns? That's not true. We've never been okay with states having the right to infringe on the Constitution. We, for a very long time, not since the Constitution was drafted, this is a newer development, but for a good long time in America now, we don't believe that states can infringe upon the Constitution either. And Clarence Thomas did point out that there really aren't rights that are not even means tested, that are almost 100% made discretionary by your state or county government. So like in California, it's county based. I don't know how it worked in New York, but basically you have to go to the sheriff, you do everything that you need to do, you put in all the work, and then they can still just say no. And they don't
How
have
do
to
you
give a reason.
reconcile that? How do you reconcile the fact that you just said, and I agree with you, that as a statement of law, that at the time the Second Amendment was enacted, this is in somehow 1791, no one thought the Second Amendment applied to state governments. In fact, you have government state Supreme Court decisions to the extent that there were gun laws, I know there were in Texas, explicitly saying, and for all the Bill of Rights, didn't apply to state governments. Of course it didn't. It was a way to get the states to agree to the Union. But now, when it's convenient for the conservative majority, we like incorporation doctrine as applied to the Second Amendment. We like implied fundamental rights when it comes to implying that the Second Amendment is incorporated to the states. That's okay. But all this abortion stuff, that's nonsense. To me, that strikes as opportunism. Implied rights when it matters. We can have a defining standard and a changing standard for what the Second Amendment means along with the times. But if you apply that to the Due Process Clause, you're insane. And that's what I mean when it's disingenuous, when it's not equal. You see these arguments applied in different contexts, and they come out to different outcomes. And that, to me, leads to the inevitable conclusion that the court is results-oriented.
So answer me this. So if we look back at the spirit of law, or what people were saying when the law was created, the segment was created, you see Samuel Adams quoted saying the Constitution shall never be construed to prevent the people of the United States who are peaceable citizens from keeping their own arms. You see the following year Tinch Cox, a member of the Continental Congress, as civil rulers not having their duty to the people before them may attempt to tyrannize, and as the military forces which must occasionally be raised to defend our country might pervert their power to the injury of their fellow citizens. The people are confirmed by the article. No, but he's talking. Evidently, you weren't listening. So I will back up, and I'll back up. So. As military forces, which is the federal government, which must be occasionally raised to defend our country, might pervert their power to the injury of their fellow citizens. The people are confirmed by the article and the right to keep and bear their private arms. Both of these are negative right. This is a negative. The Second Amendment is a negative right, and if you look back at what people were saying back when it was created,
as
this is
opposed
what
to
they
the
meant.
federal. Your quote just proves the point. The point is we're fearful of federal encroachment on state prerogatives. And the whole point of the Second Amendment at the time it was enacted, certainly not now, the Second Amendment is incorporated in 2010 in McDonald. That's less than 20 years ago. So this is a fairly recent incorporation as applied to the states. And all this time, there was no understanding that it was incorporated as to the states. And at the time it was enacted, it wasn't thought that way. But now, all of a sudden, we think that, not with history, right? Now, the history tells us it wasn't incorporated as the states, but when it's convenient for us, now we get to incorporate it against the state governments. That's that's worth knowing.
So
Let me
I'm
ask
asking
you a
you.
question.
So is the Second Amendment an inferred right? Is it an inferred right?
The incorporation of the Second Amendment to apply to states, that's an implied right under the 14th. So when you say that the New York violated the Second Amendment, you're actually precisely wrong. You're a little bit wrong. It's, if you want to be super technical, you violated the Second and 14th Amendment because the 14th Amendment is understood to incorporate the Second Amendment impliedly.
So you're arguing the intent of the Constitution was for the states to be. So you're arguing. Wait 1 second. You're arguing that the intent of the state. Sorry, the intent of the Constitution was so that the states could make laws that were against the Constitution for their state. That's what you're saying. The constitutional minds that created the Constitution. You're saying that was their intention.
First of all, the Constitution doesn't have intent. People have intent, and at the time, the original public. the original public meaning of those words, if we're going to do originalism, no one thought that the Bill of Rights applied to the states. Congress shall make no law respecting the establishment of religion. All these protections were as applied to the federal government. And we understood them at the time, that that's what it was. But these things changes. We have implied fundamental rights now. We've implied that these. I'm glad that the Bill of Rights is applied to the speech.
Okay, freedom of speech, freedom of assembly, that stuff didn't apply to individuals.
Of course not. Yeah, 1940 is when the I believe it's Cantwell versus Connecticut. That's when the Free Exercise Clause is incorporated. In 1949, I think that's when the Establishment Clause is incorporated. These are selective incorporation doctrines that happened largely in the 20th century. And if you use the original,
hang on. Your argument is essentially that the citizens of the United States should have no rights but that which is given to them by the federal government.
I agree with incorporation doctrine, but I just think I'm like a ex-girlfriend, right? Or a girlfriend. I just think it's funny that when we're talking about abortion, right, in the context of Dobbs, I don't want to have a conversation. I'm not talking about.
You'll have time to move on to that.
I'm not talking about abortion.
Wait. We can at least let him finish his point.
Yeah. I'm not talking about abortion per se. I don't want to talk about Dobbs abortion. I know you guys have a conversation about that. But when you're in that realm, right, you have all these paragraphs from Alito, from Kavanaugh, talking about democracy, and the dissent is cringing. They're saying, please, we know the Constitution is supposed to protect against democracies. Where are all those paragraphs in this argument? You have disclaiming implied rights, casting down on implied rights in the Dobbs opinion, and here it's just so obvious that we incorporate the Second Amendment to the 14th Amendment. And so I just find it inconsistent to apply like all these doctrines in the context of like abortion or whatever you want to call it. I mean, I can go to other cases too, First Amendment, wherever you want to go. But when you apply them to the specific facts of guns, then all of a sudden it's a reawakening, and we're like, of course we have implied rights. Of course, democracy doesn't go against the
issue with logic like
one
this.
second, I have a follow-up. Let me get the follow-up in here. So the argument to say is that the incorporation didn't happen until much later on, right? So therefore that implies that these rights weren't supposed to apply to individuals, that they were delegated for the states to do whatever. Okay. But the way that the law developed over history, okay, was that there's natural law and then there's governmental law that arises out of it. Anything that is silent, okay, the way the founders thought about it, the way the early court thought about it, was that those things were part of natural law, okay? And natural law didn't have to be. Natural law is not codified per se.
Where are these whole concerns about 9 unelected judges and
I got a question. I got a question for natural law. Can you tell me about corporations? I would love to hear about what they thought about corporations at the time, because they strongly opposed the ideas that would now form what we have corporate personhood.
I hate that. I hate that construct.
Well, there you go. There's a great example of people using bad originalism, and it seems to be rampant across the court.
But again,
and if you're just saying it incorporates natural law, that seems to be exactly what the originalists.
Right?
I'm sorry. If we're endeavored in finding out what natural law is from a constitutional law perspective, then you're saying that like the exact thing the originalism is supposed to protect us against is this free-form inquiry into finding individual rights. But yet your approach of natural law seems totally
no. See, now you're
philosopher kings.
You're spinning it out of control and context, right? Where the law is silent, okay. Judges have historically referred to historical precedent, natural law, and even back to Old English common law, right? Because that's where a lot of our laws are based out of. Okay, so where the Constitution is explicit, you use what the Constitution says. Where it is ambiguous, that's where the courts are open and have historically on both sides. Whether you can argue that not every Supreme Court decision has been perfectly accurate, right? There's all kinds of cases where precedent has been overturned.
So that way I understand further. MBU, can you define what you're saying when you say natural law?
Natural law is just it gets to the basic framework of like your ability to have freedom of life, freedom of movement, freedom of association, freedom to defend yourself. Okay, and that's where
the premise of the common law that wouldn't need to be adopted at the time. Wasn't that the whole point of the 1689 gun laws or the Bill of Rights of England? Why would they need to incorporate it into that particular provision? And didn't in Pennsylvania they have a provision that explicitly mentioned self-defense, and that was not accepted by the constitutional founding fathers when they were passing those in the Second Amendment. So why would it be that they?
We don't care about that history. We don't care about that history.
No.
We only care about the history that's good for us. We don't care about.
The primary basis for the Second Amendment, okay, was that the people should always be able to be armed so that they could, as a last resort, resist tyranny of the government.
Can we just look? This is it's so obvious that originalism.
Everybody today looks at everything and says, "Well, it's a self-defense thing," and the state will protect you. You don't need that, right? Well, go to Chicago, okay?
Oh, for fuck's sake.
Go to Chicago when it's easier in New York, which is the reason why this law got struck down. When it's easier for some people in New York to get a concealed carry permit because they create some sort of an arbitrary answer to a question about what is your show. Give me a show cause, and the cause and the acceptable reasons aren't defined. It's ambiguous, and when it's constitutionally vague like that, the court has an obligation to turn that back down.
Look, we're seeing.
You had to have an elevated. You have to show an elevated need. Who friggin' decides? Who decides whether that need is accurate?
Didn't the court have the authority to make determinations on what was constitutional? If we think about Marbury and Madsen, which seems to be accepted and even an originalist would defend, would they not?
Well, I have problems with Marbury. Okay, even though it's a fundamental basis, it's a fundamental basis for judicial review, right?
But you have a problem with Marbury, but this is judicial review. What just happened is judicial review. And you're saying
every case that's Marbury, right, has come down to Marbury giving the court the ability to do it, right?
You disagree with this decision.
The Supreme Court says that
this is judicial.
They are the arbiter of interpretation.
But New York democratically enacted this law, and the Supreme Court has judicially reviewed this law. And you said you don't like judicial review, so how can you be in favor of this decision?
Well, I mean, I have framework problems with the way that our law has evolved over the last 240 years.
But if
the founding fathers never meant the Constitution.
Comment.
The founding fathers never meant the Constitution to be a dead document. It's always supposed to be a living document. Excuse me.
With respect to the Second Amendment,
which is why I believe that the states need to come together and the states need to have a constitutional convention. There's a lot of questions about the Constitution right now, and the states need to get together and they need to fight it all out and figure out this Constitution, because right now there's so many problems that it would just be easier for the states to get in a constitutional convention, fix all the issues we have inside the Constitution, and then move forward from there.
But again, the problem you're going to run into there, one, is obviously the states aren't ever going to agree on changing anything enough to the point where they would actually be able to. And two, it's not going to overturn the Supreme Court precedent that is now would be then used to just judicially review.
You can't judicially.
You didn't let me finish my sentence. You don't even know what I was going to say.
Wait. If I can't, okay, let me be clear. If I don't hear somebody finish, I'm just going to jump in and I'm going to stop you, because nobody in chat can hear. Or I can hear it, and so then nobody hears what's said. So can you please finish?
Yes, and I'm sure Sprouting was going to say you can't judicially review the Constitution. Yes, but you can judicially review laws and interpret the Constitution and how it applies to those laws. So you're still not going to come to some agreement just by having the states come together and agree that they disagree about the Constitution. I want to get back to the original argument here, which is that this was an uneven application when you look at Dobbs and when you look at this case. I'm curious why this wasn't the argument a month ago when Roe v. Wade wasn't overturned, but this New York law did exist. That would still be an uneven application, but in the inverse, right? But in that case, you are prioritizing an implied right over a specifically enumerated right. And I get that I get that you're able to sort of pick and choose how you apply each individual amendment to state laws, but it would still be if it would be uneven to not allow one and to allow the other, then if you flipped it, it would still be uneven. And what Clarence Thomas was trying to refer to is that as far as enumerated rights go, we do not see any other example of one where you have to petition the government that you have This is how it was written in the New York law. Special cause above that of a normal person to be able to exercise that enumerated right. We have 0 other examples as to how that is the case. Also, in terms of the Dobbs decision, there was one justice that said we should be throwing out substantive due process altogether, and that we should review all the other cases that include substantive due process. That was Clarence Thomas. Kavanaugh, and in the majority opinion, they all said that all of the language in the decision applied solely to abortion, because it wasn't that they wanted to throw out substantive due process. It was that they didn't even think that there was an implied right to abortion in the Constitution. It wasn't that substantive due process doesn't exist, so it isn't an implied right. They said nowhere in the language of the Constitution does it seem like there is any clear implied right to abortion.
Can I just say this
wrong
is
on every count? Wrong on every count.
There's a lot of fucking waffle going on here. Originalism is being shown both in this conversation and in the last week or so to be the lie that it clearly is. It's a way of it's right-wing cope in essence, right? They're trying to reinterpret things for their own political end. They say they're against legislating from the bench, and yet that's precisely what they've been doing in a number of cases. The hypocrisy is just so obvious, and you can see them trying in this discussion to try and get around that, to try and explain how actually it's not really hypocrisy at all. Actually, even though it's diametrically opposed when it suits them, it's ridiculous.
What other enumerated right do we have to petition special cause of government for?
I'll address the merits of your argument. First off, on this, it's just Clarence Thomas. How can you compare Clarence Thomas to... Wait, who was in majority in this case? Who wrote the majority opinion here? Does anyone know? Oh, that's right, Clarence Thomas.
I was referring to the Dobbs case. No, I was referring to his logic in Dobbs.
You're saying how can I compare... How can I compare the rationale in Clarence Thomas's concurrent opinion to the rationale in Clarence Thomas's majority opinion? Is that really what you want to have say? That I can't call it hypocrisy in the concurrent opinion and a majority opinion written by the same author?
No, you can't call that it is a hypocritical decision when every other justice that was part of the majority on this case did
it still is hypocritical. It's still hypocritical.
Even just comparing majorities. For Clarence Thomas, but not for the rest of the justices who didn't say that substantive due process needed to go.
It also
Where was they hypocritical then?
It also is hypocritical for the majority. I never said that the majority opinion tosses out all of implied rights. That wouldn't give them the opportunity to be hypocritical. So it would be stupid if I said the majority says they toss out implied rights. Being wishy-washy about it gives them the opportunity to be hypocritical about it. And so, of course, I'm not saying.
Of course, they're going to carry on with the same argument.
Dobbs,
that's all they've got. Conservatism is just a talking tree.
Pursue it
just talking points.
On your point about
that's not the case for those justices because they weren't
no thinking involved.
They agreed with implied rights in the Dobbs case, just not that abortion was one, and they agreed with implied rights in the 2A case. So they were not wishy-washy. They believed in substantive due process both times.
They raised their rhetoric and their rationale. They raised doubt about implied rights, and they're very skeptical. No, both the majority opinion is dripping with skepticism at implied rights in general. And what's more is there's these appeals to democracy and how can we do that? And this is a big deal. But you don't see those same concerns with respect to the to gun rights, and your sort of text overcomes implied right thing. That's all well and good, but first of all, it's begging the question of the scope of a given right is always ultimately up for the court to decide. Now, the court could decide that the Second Amendment applies to nukes, and then all sorts of different regulations with respect to nuclear safety would be unconstitutional, and you could say text overcomes non-text. But of course, if the court interpreted the Second Amendment only to apply to the guns that existed at the time of the founding, of course the scope of the Second Amendment would be much smaller. So just saying that text overcomes implied doesn't do the work. You need to do the actual analysis of defining the scope of the right. And what's clear is, for the conservative majority of this court, the Second Amendment can change over time to fit new circumstances. If there's tasers, I think tasers came before the court. Maybe if there's some new guns down the line, some new regulations we never thought about. The Second Amendment can morph and change.
Can I give one example that's crazy?
Objection. Go ahead.
There's a constitutional case that deals with nunchucks. And they said, yes, you can carry nunchucks. Sorry, let's strike down that legislation. And I just wanted to...
Can I just say that don't mention private citizens owning nuclear weapons, because we might all drown in libertarian jizz. I'm just saying, don't do it, okay?
I say it because
Puzzle buckets of it,
people who
someone
say text overcomes implied, you're just begging the question. The question is like, what does the scope of this cover? And if you were to take the majority opinion in either of these cases, you'd think like, no. What exists of the right is at the time, the history, when it was enacted. That's what originalism is about, is extracting the meaning of these texts at the time of enactment. Well, at the time of the enactment of the Second Amendment, you had muskets and rifles. If you want to say, well, no, it's a broader value that encompasses.
You didn't just have muskets and rifles. You didn't just have
mortars.
muskets
Whatever.
and rifles.
Bro,
you had private ownership of mortars and
I'm not
cannons.
an arms. I'm
and
not
in
a, sorry.
1712 there was a high rate fire weapon called a pucker gun.
Can I
I'm not
complain
an
about
arms-
this? Because I hear this.
Okay, wait, stop. Okay, so Pisco, I want you to be able to respond to that, and then I want to give Ginger an opportunity to comment if she wanted to say anything. So she hasn't said anything yet.
Cannons for everyone.
What I'm saying is there existed some
Cannons.
set of weapons
Fuck
at
yes.
the time of the framing of the Second Amendment. And you were going to say that's ridiculous, Pisco.
Imagine
you
a
really think that
drive-by
they wanted
cannoning.
to enact a protection against the
How
particular
classy.
weapons that existed at the time of the framing.
Just like
I'd say,
it.
of course not. I think that it's probably broader than that. But the majority of, the conservative majorities never want to do that with respect to other rights.
Do you reckon they did
never
that in
want
the
to do it with
past?
the due process clause.
Drive-by
Never want to do it
cannonings.
with the history with respect to implied fundamental rights. Never even
Yeah.
want to do it with like equal protection
Take
cases.
that,
You'll
you
see them in
Prussian
dissents
bitch.
in cases like Obergefell, in cases where applying it to women. And so I just don't take seriously that when it comes to the Second Amendment, that value can change and that that value can be more broad than the specific. But when it comes to other profound constitutional protections, that's always a specific practice. That's always a specific thing. That is, I think, the hypocrisy.
So,
I think he was going to let Ginger jump in.
Yeah, I wanted to.
Hello,
give Ginger an
Carpe Pax.
opportunity.
Everyone go and follow Carpe Pax immediately.
I'm not going to say much. I just want to say that I do support basic gun restrictions. I don't think that they should be spread out to the degree that they have been. But I do feel like not everybody should own a gun just because their whim says that they want to own one. If anybody has anything with that, that's fine.
Well, that was
I
the
wanted
problem with
to-
the 2008 case. The idea that it's just this individual right.
Because you're right. People should do the work when they're talking about text and why it's important and how we should and what we're weighing it against, right? And I think in this case, right, we're looking at the text of the Second Amendment. Well, when you look at the text of the Second Amendment, KF Logan was 100% correct, right? It says a well-regulated militia being necessary to secure a free state. Well-regulated, though, does not mean what KF Logan thinks it means. It does not mean the government is picking and choosing like the federal government is picking and choosing what guns apply. What it meant was a militia that was well-armed and ready to fight. And when you're talking about securing a free state, well, what threatens the safety of a free state? Invasion and tyranny from a larger government. Well, when you look at it from that lens, because that is what the text says, you see, oh, so this applies to firearms that would give the people the capability to secure themselves against tyranny or invasion. That's why, and that's historically why, we've allowed the Second Amendment scope to broaden as weapons technology broadens.
Nukes.
But we've limited it, well, that's what I was about to get to, we've limited it based on, we're balancing it against the state interest in security. Well,
That's not what Clarence Thomas is doing. Clarence Thomas explicitly says we're not doing means testing, to means and ends, and that it has to be historically grounded. Where's the historical grounding for nuke regulation?
The
Also,
Geneva Convention?
I want to go down the.
Wait. Foreign law? You're going to cite foreign law to this conservative majority? Now we're applying foreign law to interpret our Second Amendment, and that history is relevant? This is what I mean when originalism is just pick and choose history.
I want to
Exactly,
go
yeah.
down the originalist rant because one of the things I always hear is about these fucking cannons. But here's the thing. If we're going to consider that the words are the right to bear arms, and bear in common meaning at the time meant to carry, how the fuck are you carrying a cannon down the street?
I'm not talking about cannons.
You're trying to mean that,
First
right?
off,
But they
wait,
were
first off,
drawn by
first off-
voices.
First off, I'm not talking.
case on and carried forward.
First off, I'm not talking about. We're not talking about
Okay,
cannons.
let's
We're
say-
talking
I can't name-
systems.
Can we all agree?
Well,
So answer nukes. Someone answer nukes, please.
We're talking about weapon systems such as the Cookson repeater, which was designed in the late 17th century. It used a rotating drum magazine, had a 14-shot capacity. The gun could fire all 14 shots without reloading, and that was beat out before 1776 and 1630 by the Kalthoff repeater. It was a flint rock rifle that flintlock rifle that could fire between 30 to 60 rounds per minute, and it went through multiple variations. Some able to fire 29 shots without reloading, similar to the standard magazine capacity of the Colt AR-15.
This is fucking insane.
Raditus, wait, may I?
Yes.
I've got a question. Would that be in common usage? Would you say that the average person would have that?
If you could afford it, that's not the point.
You could
If you
afford
could
it.
afford it, if you could afford it, you
because
could
common
own
use is very important when it comes to the self-defense argument, which is that handguns are in common use now and therefore should be accepted. So if you're going to tell me that there was this gun that very few people had and appears to be not common use and is dangerous,
which is why I didn't bring out the puckle gun. The puckle gun failed miserably, commercially and governmentally. The government said no to the puckle gun, and it failed commercially. These other two rifles did not fail commercially.
Do you think the founders sat down and they went, this must actually figure out exactly what types of guns on a long-term basis will be effective? Or do you think it's possible that they defined arms and then after future regulation by the states on what they want to consider arms and some constitutional interpretation, that could be dealt with in the 200 years that followed?
I'm going to respond. So the Kalthoff repeater came out in 1630. That was 146 years prior to the governing document that we're talking about. It would be well known that this weapon system was created and that people have possession of this weapon system. It would be well known.
Can I just say it's fucking insane?
The only that matters is the time. Wait, the majority in the Dobbs opinion said the only thing, the history that matters is not the pre-constitutional founding law. It's the history that existed at the time of enactment.
I disagree with much of the Dobbs
opinion. Then you agree they're being you agree they're being hypocritical. Then you agree they're being hypocritical.
Yes, I disagree with Alito's opinion. Yes, I think that Alito's opinion is hypocritical.
Now deal with nukes. So now deal with nukes. So you have. We have no history grounding of regulating nukes.
I already said regulation was not unconstitutional.
I'm sorry. I meant Jeb Tan. You think that nukes, since there's no historical precedent for regulating nukes, it wouldn't seem to fit Clarence Thomas's own test about what kind of regulations are allowed. And so I assume that private nuke usage, if you, as the More Perfect Union said, could afford it, is perfectly constitutional. Maybe you do a background check, but it has to be a must-issue nuke license.
I mean, no, I don't think, I don't think he suggested at any point that constitutional value or constitutional amendments aren't balanced against any state interests at all. I'd be interested to see where you're interpreting that he said there is no state interest to be balanced in any case other than historical precedent.
I think Binks might be having
that these kind of regulations need to be grounded in the only acceptable regulations are those that are grounded in historical precedent, and that in fact everything else is at least prima facie unacceptable.
Well, if he's writing that opinion now, and we're talking about historical precedent, and we have cases like United States versus Miller, and we have explosive regulations in the past, wouldn't that be rooted in history?
No. Then you're doing exactly what people are criticizing originalists for, which is picking and choosing when the history matters and when it doesn't matter. Just like the Dobbs opinion was citing all the history after the enactment of the 14th Amendment to support that there was no right to abortion. They were citing 1870s, 80s, 90s, 1900s. Now that history doesn't matter with respect to the Sullivan Act, right? If you're saying that later regulation matters and later enactments matter, why doesn't the precedent and historical grounding of the Sullivan Act itself, the very law at issue in this case, why isn't that the support for its own enactment?
Because again, we're having this fundamental disagreement that he is saying that only the constitutional amendments are only balanced against solely law that passed before X year. What I'm saying is you can say it has to be rooted in our history and use United States versus Miller and different cases like that as a way to say there are certain regulations that are rooted in the nation's history that the Supreme Court has ruled on. But we find this because, again, I received no answer to this question. There is no other enumerated right that is restricted in this way that says you have to specifically petition your government for a proper cause that is totally subjective. There's no rubric, and they don't have to give you a reason why you didn't get one.
Are you kidding? I mean,
No.
if you're saying other rights that are disrespected, just look at the Fourth Amendment.
No. Specifically, that you have to petition your government for proper cause in the letter of the law above that of a normal person in order to be allowed to express.
I've got one. It doesn't exist anymore. But do you remember alcohol?
Oh. Yeah.
No.
Yeah,
I do.
And that was a restricted through the Constitution, and it was at the time, had severe regulations and was an example of what you're suggesting, which was...
And what happened to it?
Also, that goes to show you...
They had to repeal it.
Yes, I'm aware.
By the way, that argument, I think, helps that the Heller was initially wrong. The fact that no other amendment deals with your individual right to own something that the government can take away, I think is better grounding for that this wasn't an individual right to own any piece of property, but in fact a right, based in state prerogatives and state militias. That and just because no other law, it wouldn't make sense to have like a prior restraint Fourth Amendment thing. It doesn't even make it makes sense.
So
and
it also,
to the extent that
are you saying that it's not possible that people just sort of took for granted that they had the right to keep and bear arms? I mean, there was no federal legislation before 1934.
And why would it need to be constitutionally protected then?
Yeah.
Wouldn't it be
No,
would deal with it?
People.
How would you even get them from the bear?
I think the average person who could read, right, and had a basis of understanding could look at the Second Amendment and say that a well-regulated militia in the time was well-trained, able to fight, could pick up a firearm and use it to defend themselves or defend their state.
So in order to get a gun, then you should have to go through state-regulated training.
You already have to.
Hunter safety was required. Hunter safety was required for me when I was in high school.
Wait, sorry. Rejected by most of the court historically.
This case does not disallow the need to take a safety class for a concealed carry permit. That is not at all what this case does. It says just the proper cause requirement is the unconstitutional.
No, but why shouldn't they have to? Why should they have to go through that class? Is there really any historical precedent of 1800s governments like saying you have to go to like driver's school for or gun school? Where is that precedent?
There were cars in the 1800s.
The construct of it being a well-regulated militia, right? That has
the
to
value,
matter.
right? This broad value. And they never like this wishy-washy broad value stuff with respect to all the other like lib rights. But you like it with the
well-regulated meant well-trained, right? Proficient in the use of firearms.
Yeah,
at the same you have to think we're going back to 1776. At that point in time, the government found that all men that were citizens were supposed to be part-time soldiers. They were supposed to be able to protect the land should they need to. This is you can read the debates, the back and forths that the founding fathers had, but this was the idea when they said the well-regulated militias. They viewed all men because we were sexist and racist, all white men, because we were sexist and racist back then. But that all white men were that we were part-time soldiers and we should have the ability to stand up for the country given the time needed. That we would stand a raising army, because at that point in time we also didn't have a standing army. We had no standing army whatsoever. The only thing we had was a standing navy.
Why are licensing schemes allowed? I mean, were there? Someone help me with the history here. Were there widespread licensing schemes in the 1800s for getting a gun, or was it pretty much you just have to have it?
No.
So I think by MPU's logic, if you're doing the history right, constitutional carry everywhere, right?
Yeah,
mandatory.
And
mandatory.
And
no, but as a constitutional matter, not as a policy matter, as a constitutional matter.
Yes.
Okay.
I don't think states should have to force you to get a license.
Okay, then let's go back to the nuke example. You think that there's constitutional carry of nukes as well?
No, because how would you carry a nuke?
Why? Oh, so please.
No.
What about tanks?
So hold on. You said they led on history, right? They leaned on historical precedent and what people generally did in common use, right? No one was commonly carrying nukes at the time, and there's no way to commonly carry a nuke. So that would be the history of their
I've got a history.
MPU doesn't
I've got a
agree.
history
MPU
problem
doesn't.
for you.
Also, look, fissile material is actually something that's pretty heavily regulated, right? So you can make everything except you can make everything you can about an atomic weapon except not have fissile material. It's not a bomb.
Who cares that it's regulated now? The New York, the concealed carry. That was a regulation that. Oh my bad. Sorry.
I said I wanted him to finish.
Yeah, I'm sorry.
If you can't get the fissile material, you can't make a nuclear weapon.
Fizzle.
Do you think it's okay for the government to be like,
Fizzle
we ban
material.
bullets and we ban gunpowder?
Nope.
Okay, so then what's this nonsense? You can ban a component of the weapon, and that would be just an end run around the bare arms. You think this court's going to allow that? This court's going to allow you to be like, oh,
No,
we're just
I
going to
think
say
that-
that you
I
can't have
think
gunpowder?
there's-
Gunpowder.
Look,
Yeah.
there is a compelling interest in the state, okay, to not have a
No,
caustic.
historical basis. We need a historical basis, sir. That's what this
Oh, the Supreme
opinion
Court,
relies on.
No, the Supreme Court routinely defers to state interest. Okay, that's the balancing
Yeah,
test.
that's
that
the
they're trying to
point.
do,
That's why
right?
this is stupid. That's why this is dumb. Because
You
it's saying
know,
like,
look, everybody that argues against the Second Amendment or argues for more gun laws, right? They do it as a policy prescription. You're trying to use the Constitution in a way that just says we're going to have nobody have any guns. We're going to be fucking Australia or we're going to be New Zealand and some.
Well,
such,
this
right?
this is disingenuous nonsense. People arguing in
not.
favour of
That's
some
exactly
gun
the end point.
regulation.
That's why you
of
have people
some-
like Beto O'Rourke, who's running
You've
for
told
governor
quite a
in
lot.
Texas, who
Come on
says,
now.
changing the
No,
subject
he's-
of
he's-
policy
wait,
is
wait,
more
wait,
we're
wait,
comfortable.
coming for your
stop,
guns.
stop,
Joe
please,
Biden says
please.
we're coming. Go ahead.
Okay, sorry. There's like three of you talking at the same time. I wanted people to go in order, so we're gonna go Santa Claus, then we're gonna go Kevin Logan because he hasn't said anything in a while.
Yeah, the notion, right? The notion that everything that is done by the left today with respect to firearms laws and regulation is about making it more difficult for the average citizen to keep and bear arms. Period. It's about confiscation, but they can't say that other than like Beto O'Rourke, right? He says, "Yeah, we're coming for your AR-15s." Okay, we're coming from
king
your,
of the
we're
left,
coming for your
Beto
AK-47.
O'Rourke,
Let me
yeah.
finish, please. This is what everything that they're doing, the way that they're choosing to try to interpret this is about trying to get guns out of American society. Okay? Every gun law that we have in this country, particularly in states like New York, Illinois, California, we see massive amounts of gun violence that still happens there. You know why? Because criminals have the guns and they don't care about the laws. So the only way you end gun violence is you have to confiscate all firearms. Now the left, they would love to do it, but they know they can't get elected by saying that.
Well, thank you for taking us down the conservative conspiracy theory talking point
It's not
tree
a
there.
conspiracy,
That's
Kevin.
precisely what that is.
No, it's
Asking for. No, it's not. Jesus. Right, asking for sensible gun regulations is not the same as wanting to come and take all of your guns, okay? No one's coming for your fucking guns. You're going to be able to own guns. The Second Amendment isn't going anywhere, okay? But what you could have is a reasonable look at gun regulation and, deal with it from there. This level of cope is fascinating because the arguments are so fucking disingenuous. So obviously
Okay, so
disingenuous.
Beto O'Rourke's
Excuse
saying
me,
that
don't
we're gonna
interrupt
come
me,
for your
sir.
AR-15,
I
right?
don't give a fuck about
but-
Beto O'Rourke. Beto O'Rourke is not the king of the left, okay? No, Beto O'Rourke's a fucking basic bitch liberal. I don't care, right? The point is, the arguments are disingenuous because people like the More Perfect Union will never accept any regulations on guns, basically whatsoever. He might as well come out and just say, yes, I want to own a nuclear weapon, fuck your safety, right? Because that's ultimately the point of it. So all of the arguments are disingenuous. Their outcome is already established before ever thinking about the topic. So it's sort of almost pointless talking to someone like More Perfect Union about this because you're talking to a brick wall. You could never convince him of anything because he's not really thought about it particularly.
And you saw what
I'm the
happened
only
at the
person
end
on
there.
this panel that actually worked on nuclear weapons, by the way.
When we were asking,
Good for you.
About the logical limits, about applying Clarence Thomas's historical analysis, and where there was in the historical record any basis for nuclear regulation, the More Perfect Union, uncomfortable, goes on some totally unrelated tirade about his perception about what politicians are doing, instead of dealing with the fact that, by his own logic, constitutional carry not just of small arms, not just the arms you can carry, but of nukes. And I want him to deal with that. Why would nuke regulation be acceptable? The one argument he gave is, well, it's okay for the government to regulate a component of nukes. You would never make that argument of guns generally, that it's okay for us to have bullet control and therefore the government can make an end run around the Second Amendment just by banning bullets. And so can I please have somebody on this panel give me a constitutional basis for regulating nukes that's grounded in Clarence Thomas's historical analysis?
I did.
Okay, let's hear it.
Like your guys' arguments of common use. Since there was no historical way for people to carry indiscriminate arms to the level of a nuke at that time, then clearly the Constitution wouldn't necessarily automatically give that implied right to carry a nuke. It's the same logic they used in Dobbs.
So then,
there's no language that even closely suggests that abortion should be a right.
So
and therefore,
Jeb,
no
then should we ban shotguns?
But wait. Sprout, I couldn't hear anything he was saying. Jeb, please finish.
I mean, I was pretty much done while he was going on. I was basically just when he came in.
Sprout is going to hit you. Sprout is going to hit you with a shotgun example. Sprout is going to hit you.
100%. Go ahead.
Should we ban shotguns? Should we ban sniper rifles? Should we ban 50 caliber weapons? Should we ban any of these because these were not common use at the time? If you're gonna say that's the historical analysis, then you also have to get behind banning shotguns and sniper rifles.
No, I'm saying relative. You have to look at the relative arms, the relative strength of arms between private citizens and the public government, right? Nukes, even at the time, would have been wildly disproportionate to what the state could own or carry. The Constitution's been pretty clear that the point of certain weapon or having the right to bear arms is the security of a free state.
Hang on,
not
but
for offensive
but they
power
now
to be able to
with rocket launchers.
the American government now the American government now has nuclear weapons.
You're tripping over each other, and I can't hear any of you. Okay, so Jeb, can you say that again? And then we're gonna have Kevin go. And then we're probably going to start looking towards moving on to the next topic in the near future.
Yeah. So basically, it's not necessarily that the specific weapon wasn't carried at the time. It's that nothing as indiscriminate as that weapon was carried at the time. I think there's pretty good precedent for dealing with indiscriminate weaponry differently than discriminate weaponry. Discriminate meaning you aim and you shoot at what you're trying to hit. Indiscriminate meaning it's very likely going to kill someone.
This is the problem, Jeb-Tam. Just to be clear, this is exactly the problem. When you're picking and choosing, there's always going to be differences, factual differences that you can distinguish things on. You just picked a couple, which those are absolutely factual distinctions. Common usage is a factual distinction. Whether or not it's indiscriminate is a factual distinction. The originalist just gets to pick and choose which historical difference, factual difference, is dispositive in making their ruling. And by that virtue, it carries just the same hallmarks of legislating from the bench that living constitutionalists are accused of all the time. And so I think you just saw it right now that there isn't really, in fact, a historical basis for regulating nukes or regulating or having licensing schemes. And they acknowledge that. And so by their own logic, I think licensing schemes ought to be unconstitutional. And indeed,
I agree. Licensing schemes should be unconstitutional. Yeah.
But that is not what the opinion ends up saying. And so that's why I say this opinion, I think, is ultimately hypocritical. Because if you're having this deep grounded history and regulation, unless you're taking this loosey goosey, hippy dippy, to quote a phrase, interpretation of a broad value. And that's exactly what the living constitutionalists are excoriated for all the time, is for taking a look at broad values and applying them to the situations today. They're called political actors, but when they're doing it with respect to guns, they're called faithful interpreters of constitutional law.
Then why wouldn't it be hypocritical to then do the inverse and not overturn Roe v. Wade, but continue to allow proper cause arguments to be used in I'm just to be clear. I'm taking a hit at
Robert's point.
Just to be clear, I'm taking a whack at the hypocrisy, but I do agree. If you're going to have an individual, if I take for granted that there's an individual right to bear arms, of course that right should be a broad value that endures over time and it fits to new situations. Of course, that makes total sense, because the number one principle of our Constitution is to have a union that lasts. And so, of course, I would think that it makes complete sense to have these regulations sort of line up with what it looked like at the time. And
so you don't agree, you don't think the case is wrong. You just think it's hypocritical. You think
no, I think the case is wrong because the case is wrong because it applies. I don't agree with Heller, and so I disagree with Heller at base. I think it is a state's prerogative, a state's right. That's, for me, the history points that way. But if I were to accept that there was an individual right, I would also disagree with the test that they apply. I don't agree that it should be this historical focused test. It should be a scrutiny, tiers of scrutiny analysis, like most of these other rights are sort of analyzed under. And so I disagree for many reasons, but I take a special issue with hypocrisy. And I think
the state should be able to violate, say, like someone's Fourth Amendment right because they didn't show proper cause as to why they should have it?
I'm sorry. Are you familiar with Fourth Amendment jurisprudence? You have so many exceptions to the Fourth Amendment, they swallow the rule. You have, hot pursuit, exigent circumstances, plain view, and recently Supreme Court precedent that's like overturning your remedies to be able to seek out.
Don't all of those have to be have to do with like immediacy concerns?
No,
right?
No, plain view is not about
hot pursuits right now, right?
Exigent circumstances, plain view are not necessarily.
Exigent circumstances mean it's in the moment, right?
No, but
pursuant to an arrest and
so
probable
what I'm
cause.
saying is, so you're okay with
you guys are tripping over each other.
So those exceptions are grounded in history, but not all of them. Like the vehicle, where's the motor vehicle exception of the warrant requirement? That's another exception that we've sort of acknowledged, that you have less rights with respect to searches and seizures in your car. All you need is probable cause. You don't need a warrant to have your entire car searched. But of course that makes sense because the value of the Fourth Amendment carries forward to new situations in ways that the framers of those amendments expected. And I think that the majority
be able to say you don't even need probable cause if someone has not yet petitioned to the government that they have the right to probable cause.
No, I don't even know how that would work.
Exactly. That's the parallel here.
No, I don't think so.
You're saying in order to have that right, even in the most basic sense, in order to have that right, you have to petition the government for that right. And
then why do you agree with why do you agree with mustache? Then why do you agree with background checks and felon restrictions and why do you agree with all that stuff? If your analysis is nowhere do you see, by the way, in the Fourth Amendment jurisprudence that all of a sudden because you need to have a background check before you have probable cause protections. Nowhere do you see you need to have felony checks.
Well,
there's some stuff on that on parole stuff.
The background check thing applies to everybody, right? As opposed to the case in the law in New York that says in order to get a concealed carry permit, you had to show cause above and beyond.
That applies to everybody. No, that applies. Okay, the rule applies to everybody. The rule is stringent, but it applies to everybody. But there's just the rule wouldn't make really sense in other rights contexts, and I think that's further evidence that the Heller was wrong, not evidence that somehow these regulations are.
Wait, so because a regulation that seems to violate Heller was wrong, it then invalidates Heller?
I actually want to go down this route because I think the problem is that any of the if states have the same problem because they incorporated a bunch of these ideas about felons can't have guns and mentally ill people can't have guns and kids can't have guns and we need to have training for you to have guns and you can't have a gun in a school zone or in a federal zone based on nothing. So they just made up a bunch of shit in the Heller decision and now those are acceptable, but these new standards are not. So if you're going to say everything's out, then that's okay. But it's just odd that if we're going down Pisco's argument of there should be no regulation or you have to allow regulation and allow things to move on and allow individual states to be able to make those decisions, I think it's just consistency.
And what I'm saying is there's always a balanced interest in issues like that where how far do we take this before? I mean, yes, there still is. Because again, you would disagree that you said you would disagree with this ruling even if they weren't being hypocritical, but you wouldn't agree with laws that restrict any of the other fundamental rights outlined in the Constitution.
Of course I do. Of course I do. With respect to Dobbs and abortion, Roe and Casey established reasonable restrictions that you can have even in the first quote-unquote trimester, even though that wasn't the dominant framework with Casey going forward.
That you had to specifically petition your government and get them to say you have probable cause.
I was about to go there. For the First Amendment, what do you think we do with confidential information? Confidential information. Are you just allowed to give it out to whoever you want? That is speech, technically, right? I'm talking. I'm communicating thought. But I'm not just it's almost like a prior restraint on me. Some of you guys think that Hillary Clinton should be, I'm sorry, I shouldn't assume, in jail for spreading classified information. Isn't that sort of like a prior restraint on speech in some way?
No,
I don't know.
She is not forced to petition the government for her ability to have the general right to free speech. She's entered into a position that gave her privilege to information the public wasn't privileged to, and so she lost that right in certain
Well, that's you begging the question and assuming what's the core of the Second Amendment. I mean, the core of the Second Amendment might mean the right to petition your government to have a license. You're saying it's not that, and again, I just think that's question begging. Maybe the right is
bear arms. That's why it's not really.
Well, I think the big problem is that it says shall not be abridged, and everything that has been done via law. Now you can make an argument, right, that there are reasonable restrictions, and you can show the benefit. Hang on, it says shall not be the right of the people to keep and bear arms shall not be infringed.
Yeah. So why are you okay with any regulation? It says
What?
shall not.
No, I mean, this is kind of the problem, right? So, we talk about like how we want we want the nation to be evolved and to be constantly aware of things, right? We have this process that we can amend the Constitution, and if there are 70% of the people in the country, okay, which is kind of fucked up, because the 70% is like a survey of 895 people or something like that, right? And then they oversample certain groups or whatever, right? You have to look at the methodologies for these surveys, but they say 70% of the people in this country want universal background checks, want to do this, want to do that, okay? But then they're okay because a lot of people are the 70% are probably the people that don't want guns anyway. Right.
If
I don't know that.
If 70% of the country wanted to like jail all Trump supporters, would you say that's okay because 70% want to do it?
Well, you got about half the country that wants to jail all Trump supporters.
Oh yeah, so
and the news media is totally okay with that, right?
See, just more conspiracy bullshit.
This is going
no. When we talk, well, I don't want to get too far off. I took his argument, I ran with it, so I apologize. But the idea that if you are going to create a reasonable restriction, you ought to give the most deference you possibly can to what the literal writing, the black and white meaning, okay, of what the Second Amendment is. I'm not saying that you can't come around and do something, even though it says shall not be abridged. We have created precedent upon precedent upon precedent over the last nearly 100 years. Okay, since 1934, when the federal government really got involved with significant regulation of firearms.
Oh, it doesn't say shall not be abridged. So just so you know,
infringed.
Yeah,
What?
infringed.
Yeah,
Not abridged. So
sorry. Yeah,
yeah, I mean
Well,
that's an important distinction, right?
Again,
fair enough. But infringed. Okay, what does infringed mean?
Infringed means the
infringement
rights
mean,
taken away, not the rights restricted.
It means reduced. Reduced in scope. It's limited. It's whatever, right? Anything that prevents a free citizen, okay, from keeping and bearing arms.
The definition of infringe. The definition of infringe is to actively break the terms of.
Okay, first of all, don't just Google it. If we're doing this historical analysis,
if he's asking for a definition, I gave him a definition.
I just find
What's wrong with
really,
Googling a definition?
I'll tell you why. Because the Clarence Thomas opinion isn't interested in.
Did you Google the Clarence Thomas opinion? I'm just curious. Like, did you Google it while you're giving this guy shit for Googling a definition? Did you Google the Clarence Thomas opinion?
You don't even know where I'm going, right?
I'm asking you while you're giving this guy shit about Googling something. Did you Google that opinion? I'm just curious.
I'm not giving him shit for.
Yeah, no, I mean you were. You literally told him he should. Let's not Google definitions. There's no reason not to. So.
You don't know why I said that. Because the
so what? I'm asking you specifically. I'm going to ask you one more time. Did you Google the Clarence Thomas decision? I just want to know. Okay, thank you.
Okay, my problem isn't with Googling. The problem is, and the reason why this originalism debate is so hot with dictionary wars, is what matters for originalists is not dictionary definitions today.
In case you were
wondering. Well, how do you know what a legal definition is?
It's an original public. It's not a legal definition.
Well, no, I'm asking you. If you're reading a court decision, there's a difference between a legal definition and a standard definition for a word. So how do you determine? So I'm asking. So I'm going to try. Let me finish. I'm going to ask you. How would you be able to determine what a legal definition was, as opposed to a standard definition?
Google.
Not interested in.
Well, wouldn't you Google? Well, I'm just saying. Wouldn't you Google the definition? Wouldn't that like save you a lot of time?
No, you wouldn't.
You wouldn't?
No, you wouldn't. You would get. He cares about the dictionary definition in the 1800s. That's the original public meaning.
Yeah, but that's not.
You're not a lawyer, are you?
That's not my. So that's not my question again.
Talk about things you don't understand.
One more.
You don't come in here like.
I'm sorry.
The basis of these opinions is.
Okay, wait. Please, both of you stop.
I'm asking you, Scott. Are you a lawyer?
Okay, give me a
second.
second.
I am.
No, you're not.
Give me a second. Please,
Yes,
give me a second.
Let's show me your fucking law degree.
Please, do you want me to, I
Yeah,
don't want to talk about
go get your fucking law degree and let's see
Do you
it.
want me to get it?
Yes. Go get it.
Okay.
Well,
He's
that's
gonna dox himself.
That's been said. By the way, the 1776.
Is my mic working or is it not working?
It's just hard to hear you when other people are talking, but I heard you now, so I was shutting up.
Okay. Sorry, it must be my mic just must be low. I'll see if I can fix that in a second. But with that, I think we're about an hour and 30 minutes in, which means we probably get to the next topic. Oh, and there's.
I can't fucking believe this guy actually went and got the fucking degree.
Wait. I want to address
he's proud of it. He's proud of it.
So what he doesn't understand is that originalism, the doctrine which Clarence Thomas, in majority opinion, relies on, doesn't care about what people.
Well, hold it up to the camera, right?
I don't want to dox.
Hold it up to the
if I not dox myself?
Well, how do we know it's an actual law degree?
You can hear me talk, and you'll be able to know I'm a lawyer.
You know, that's shit. You know, you could be a great con artist, right? Like maybe all you grabbed off of, maybe it's a dog walking degree. How would we know?
I'm not gonna dox myself right now. But
no, I'm just saying. I mean, it's
a lawyer.
Shit, just saying.
You might do it later.
Why don't you let me explain?
Okay.
I'm not even.
Okay, so this is what we're gonna do. Okay, we're gonna wrap up, and we're gonna let Pisco go first, so he can give his explanation.
Sure.
And then we're gonna go around the room.
So this person who just came in, Andrew W., clearly doesn't understand what Clarence Thomas's whole
pop a fascist to you, lawyer boy. Use the right legal terminology.
Okay. We're wrapping up. No interrupting other people during wrap up.
Andrew Wanker
is not unlike what Clarence Thomas cites for historical precedent in defining the scope of individual right itself. He cares about the original public meaning of the text. Clarence Thomas is a textualist and he's an originalist. He doesn't care what the definition of a word is today. He cares about the definition at the time that law was enacted. And so, of course, Googling a definition right now would be precisely the kind of evidence that Clarence Thomas and Scalia would admonish you for using. What you need to do is get a historian and ask them what those words meant at the time they were enacted. And they would look to, what did people at the time look at? You'd look to Blackstone, look to treatises. And so you're, admonishing me for admonishing More Perfect Union for Googling a definition now. Clearly, it's because you don't understand anything about originalism.
Wait, okay. And I said, okay, let me make this clear. During any statements, nobody else talks. This is his time to talk. You'll get a time to talk, I'm sure, too. Okay,
does he ever stop talking?
Andrew W., I mean, if this is his first foray into legal analysis, it's not looking good.
Next, I'm going to throw it over to Andrew just to see what happens.
Yeah, so I was just curious. So once again, let's move all the way back here to you giving this guy shit for Googling a definition of a non-legal term.
Fuck's sake!
Right? He was Googling a definition of a non-legal term.
Fucking hell, man! Google.
Is that correct or no?
Google.
In 2022, yes.
Okay, so was the definition that he was looking for infringe? Do you think that infringe had a different meaning in 1776? I'm just curious.
Yeah, words move on.
You don't know. So
why is historical analysis, buddy?
I'm asking you. So again, why is it that you're giving this guy shit for Googling the term if you don't even know if it had a different meaning at the historical time that you're referencing? I'm just curious.
Okay.
It's
okay.
No, I'm mocking you. I'm not talking about Thomas. I'm mocking you.
Both of you, please stop.
All
this is ending statements. We need to wrap up. I don't want to continue the debate any longer because I want to make sure we can get to school prayer, which I'm curious to get everybody's take on. I want to throw it over to Jeb Tan.
Yeah, so I think generally in the conversation, people can feel that the ruling might have been hypocritical, but at the end of the day, I don't think it's wrong, whether you think it's hypocritical or not. I think if we look at the historical analysis that's been done in the Second Amendment, well-regulated militia just meant that the people were ready and armed to fight, and that the way the constitutional amendment was ordered wasn't to say that you only get the right if you're in a militia, but that you get the right because the state has a right to a militia. And when it comes to the logic behind why this case is wrong, I don't buy it because, again, I still never got my question answered to another right where you have to specifically petition your government that you have proper cause above and beyond that of a normal person in order to be afforded that right. Everything else that was mentioned was you performed an action, and so you lost a right due to that action, or you had something present in a clear view, and so you lost a right. But none of them had to petition the government for proper cause specifically above that of a normal citizen in order to get access to a fundamental right directly enumerated in the Constitution.
Okay, next is going to be Kevin Logan.
Yeah, I mean, I can only reiterate what I said earlier. Originalism isn't a real legal doctrine. It's a smokescreen. It's a mask that people who want to do essentially conservative legislation from the bench put on to try and pretend that they've got the founding fathers on their side, as if what some people said 250 years ago should directly impact what's happening right now, as if they themselves didn't think that the constitution should be constantly updated. It's a very strange thing. Also, just on the idea of, I mean, Jeb Tan's walked away, so I don't even know if he can hear me, but his redefinition of well-regulated militia is very, very funny. I mean, that's obviously not at all what a well-regulated militia is or could realistically be described as. You and a dozen other people who don't know each other are going to join together and take on the most armed government in the history of the world. It's not going to happen. It's so obviously a fake argument, again, thrown up as a smokescreen. The Supreme Court can eat my dick.
Okay, I don't know if they will, but I'm sure they'll take it.
Well, look, the offer's on the fucking table. That's all I'm saying.
Okay.
No historical basis for it, though.
Thrown over to Sprouticus.
Obviously, Kevin's still mad about the Revolutionary War. So what I'm gonna bring up now is the 1776 definition of infringe. One is to encroach upon in a way that violates law or another rights of another, or two is make it obsolete or to defeat it. And so I would argue that that infringe does not block regulation, but instead blocks from the right being taken away from the individual completely. It does not block regulation whatsoever. So with that being said, I think the Supreme Court made the correct decision with the New York case. I don't think you should have to give a justified cause for self-defense to be able to have this right. I think it's an undue burden, but I do think the Supreme Court made the correct decision. But I also do think that regulation does belong within the Second Amendment.
Okay, now I'm going to throw it over to More Perfect Union.
Yeah, the reason why the historical meaning of the words in the Constitution matters is that if you just simply say that whatever we define a thing to be in modern parlance opens up the ability for jurists to just
he nearly said Jews. He nearly said Jews.
So understanding the original meaning of the words actually acts as kind of a break, a check, to prevent them from actually doing that. Now, we know they do this all the time, right? Because they manufacture reasons. This is why the Supreme Court overturns itself all the time, right? All the time. They get stuff wrong. Plessy, Dredd, just tons of cases where they've ruled one way, and then 15, 20, 30, sometimes 50 years later, they come back around and then they take a fresh set of look at it. And they're, Kevin, you may think that that originalism or textualism is just a smokescreen, but Democrats use it as well. Okay, they have used it to justify cases in the past.
So don't fucking care.
If they're doing well, I think that's just kind of a problem. And the whole thought process about
does he think I'm a Democrat?
Saying that. Well, never mind. I'm just going to end it right there because in the sake of time.
Okay, I'm gonna throw it over to Ginger.
Okay, so unfortunately, I feel like the amendment was written poorly. It's so vague that it's
you can't criticize the founders.
Realize what they actually meant by the meaning, even though they say that it was made specifically so that they did not have to create a solidified army. And now we have that army, and now things should be a little bit rectified, but nobody wants to rectify the situation. Like I said, I feel like, although I feel like it was from a constitutional perspective, that there was no problem with the court ruling, but I do feel like that there should at least be some baselines as to who should
against
own a gun.
democracy.
That's how I did.
Okay, and wrapping it up with Franklin.
Yeah, I think it would be really great if the decision of who could own a gun was left to either the individual states, as that was likely the intended interpretation based on their legislation, and you would have a more responsive situation in the individual states you live in that care more or less about guns. specifically in New York, it was like 80% that disagreed, or disagreed with the finding and agreed with the original holding, or the original form of the legislation.
You can originally hold these
It
notes.
seems to be that when someone cares about a constitutional right, people will make strong originalist arguments about what it was supposed to mean. There's a long, arduous history of each individual jurists saying, of course that wasn't the intended meaning of that decision. But the NRA fought a really successful civil rights campaign to get guns. So I think in terms of applying the law in this given situation, I disagree with the initial holding in Heller. And I also disagree with New York's new plan, which is to call almost everything basically sacred land, which will be buses and I think it's buses and New York
protests.
Times Square.
Protests.
Basically everything is now magic land, and that's because it was a really bad decision in Heller to just make up shit. So don't do that if that's going to be your big defense argument about how you don't make up shit. Don't make up shit, or people will use it.
Yep.
Okay, that'll be it for wrapping up those statements. The last time you can talk about
What's my
this
closing
topic...
statement, Burns? I don't get a closing statement? I'm fucking chopped liver over here or what?
Exactly, you're chopped liver. Okay, you get a closing statement. Sorry about that.
All right. So
wait, did you get one?
Yeah, right after Pisco.
No.
Yeah, it was right after Pisco.
I don't think he realized it was a closing statement because he was also
didn't know.
asking Pisco
I don't think.
questions.
Yeah, no, I didn't get it. Well, I don't know. I jumped in the panel midstream. I don't fucking even know what's going on. I just
you another
keep it super short, right? 30 seconds. Guns are fucking awesome and based. Fuck all of you who want to take them away. You can't have them. You can kiss our ass. Fuck off. Right? That's, I mean, let's just be real about this. This is the actual American sentiment. Fuck you. They're ours. Kiss our ass. That's what actual Americans think about it. Just so, I heard some accents. They sound like maybe they're across the pond, right? They sounded like they were kind of based, but yeah, that's the actual American sentiment. Fuck off.
Okay. Now, the last time you can talk about this topic is in the intro to this next topic. Use your time wisely, because I won't let you all go on for minutes and minutes and minutes. The next topic we're going to be discussing is prayer in schools, because that's the next Supreme Court decision that has happened that is a lot of people talking about. The court sided with a former high school football coach who was fired after leading post-game prayers on the 50-yard line. Waiting for the conservative majority said, Gorsuch, writing for the conservative majority, said the coach's prayers at the public school event were protected by the Constitution's guarantees of freedom of speech and religious exercise and did not violate the prohibition on the government endorsement of religion. Do you agree or disagree with the court's decision? I'm going to go start with, Sprout. I haven't started with Sprout yet.
Right, so I am going to agree with the Supreme Court's decision in this case. I believe that it was the person's right to individually pray, which is, I've looked at this case, that's what it was. The coach was individually praying. There were students that joined after, but he had been doing this for years at that point. He was individually praying, and the Supreme Court fired him because of constitutional worries. So I agree with the Supreme Court on this decision. I think that they made the correct decision here to allow someone to pray. If someone was Muslim, I would say just as much that they should be allowed to pray and practice their own religion, as long as it's not coerced. As long as you don't coerce students and you are not coerced yourself, I believe that the freedom to practice your own religion should remain a value in the United States.
Next is More Perfect Union.
Yeah, I think it's a good decision. I'm not particularly religious myself, but I do understand, again, getting back to what the framers had actually intended, right? If you recall, the Church of England was the prescribed religion for the colonies. And the founders didn't want there to be a state-sponsored religion. So when they say that no law would be made with respect to the establishment or an establishment of religion, they meant the state will not create a church. Okay, the founders, the vast majority of founders, were morally upright men. They were religious. They thought that it was a key tenet to live a moral, upright life would be that would be the citizen legislator who would, you know, participate in the government for a while, but they would do things in a morally upright way. The Constitution, by saying, yeah, you can't establish a religion, the Sprout's point, the coach did not say, I'm going to be doing this on company time. The game is over. He's doing it himself. He's expressing his own religion. That's the second half of that amendment that people sort of get freaking twisted about. You can't create an establishment of a religion, but you also can't prevent or legislate the free exercise of somebody doing that, right? So he's expressing his faith. He happens to be doing it on a public piece of ground. The school is obviously not intending to endorse him. They're not paying him to do it. He's not coercing or trying to convert people into joining in prayer. This was a spontaneous thing that they all did as an expression of their faith. And yeah, it should be a protected right. And a lot of people, like, you know, blew up Twitter and Twitch talking about, well, you know, if some Muslim was out there doing it, you know, these people would be just going crazy. No, religion's religion. If it's your belief that's your religion, fuck it, man, do what you want to do. Just don't do it under the guise of the government. And it's clear from the case law that was presented here that this coach wasn't acting as a state employee when he was doing it. So yeah, I totally agree with it.
Okay, I'm now gonna throw it over to Pisco.
Yeah, I'm not surprised that some of the conservatives in this panel have gotten the facts wrong, because the Supreme Court of the United States got the facts wrong in this case. It's clear based on long-standing Supreme Court precedent that the display by Coach Kennedy was public speech. Even though it was at the end of the game, he was absolutely on the clock. He had duties to attend to, staying after the game, an instructional role for the children. He had broadcast that he was going to be doing this prayer. There was a media blitz about it. And it's just like the teacher praying cases, which are classic historical violations of the Establishment Clause. And on that basis, you know, both his free exercise and free speech claims are dead in the water at the start. But even if you believe this was private speech, he still loses. Under well-established, until now, Supreme Court precedent, you are absolutely able to weigh, for public employees who take public jobs on conditions, and they understand those conditions, you are able to balance both the private interest in speaking on a public matter and a matter of public concern, along with the state's interest in maintaining decorum and preventing unlawful activity. And I think it's clear, based on the merits of this case, that this would be an establishment violation that would satisfy the burden under either the coercion test or the endorsement test. And the Muslim examples aren't supposed to make you feel like, you know, a regular Muslim versus a regular Christian, whatever that means. Think about this example, and let's see if anyone will answer it tonight. Suppose that someone was doing a private Wahhabist prayer in the style of ISIS. Do you think, in the same facts otherwise, do you think the school would be within its rights to sanction the coach making a Wahhabist ISIS style prayer in the middle of this field? If you can answer that one, you know, let me know, because I think that everyone here would say, of course not. I mean, of course they can sanction that. It's disruptive as hell, and it would absolutely be a coercive infringement on the Establishment Clause.
We work well at intimidating the other team, though. I'm gonna throw it over to Jeb.
Yeah, I mean, in regard to like the final sentiments on the last topic, I heard that it would be foolish to say that a well-regulated militia means what many constitutional and historical experts agree that it means, which is a people that are armed, trained, and ready to fight at any given time. I think it would be 30 million times as foolish to think that a militia designed to protect the people against government tyranny should be well regulated in the sense that the government they're meant to protect themselves against gets to decide when, how, and who gets guns. In regard to this topic, VPF knows my love for the separation of church and state. But I do agree with the court in this decision that his ability to freely exercise his religion at the end of a game, at the conclusion of a game, it would be his inability to do so would be an unreasonable extension of his duties as a coach. And seeing as how the game was over, right? Even if he did have duties after the fact, teachers are still allowed to pray on their breaks. So even if you have work duties before and work duties after, you are still a private citizen allowed to express your own religious beliefs with whoever consents to express those beliefs with you, as long as it's not a part of your duties as a state official. And so I agree that he should be able to pray after games. And if we're looking at the American tradition side of things, I don't think I've ever competed in a wrestling meet or a football game wherein we didn't pray after. So this case honestly caught me off guard that it happened at all.
Okay, now I'm going to throw it over to Kevin.
Yeah, just going back to the previous topic, the fact that you had to bring that up there, Japan, is hilarious. I'm glad you were seething about that. Moving on.
My last chance.
Whoa! Opening statements. God damn it. Anyway, as to this topic, I think the decision was made on incredibly shaky and shoddy ground. The facts as laid out by More Perfect Union were basically entirely wrong. Justice Gorsuch saying that it was a short, private, personal prayer is fucking ridiculous, given that it was in public in front of hundreds of people, and this man clearly has some coercive power over the students. The idea that they were in some way infringing upon his freedom of religion is farcical, given that he was it was on company time, so to speak. He's an employee of the school, or was at the time. The school literally offered him a more private space that he could pray in if he so wanted to, which again I still think would actually be bad, because he shouldn't be praying at all during that time, really. But they did offer him a more private place for him and the other people who wanted to go and pray. He refused to do that. He wanted to do it strictly on the field, right there in front of everybody, which is not just biblically hypocritical, but is also clearly therefore not a personal or private religious engagement, but more proselytizing, which is precisely what this is. This is clearly a rather significant blow to the separation of church and state, and a move towards some sort of horrific theocratic legalization. I think this is completely fucking wrong on a legal and moral basis.
Andrew? Also, if you want to introduce yourself, you haven't yet. So.
Yeah, my name is Andrew Wilson, also known as BPF. You can find me on The Crucible. I'm the host of The Crucible. We also do debates, panels, all kinds of other shit. Anyway, let me just dive into my opening. So this is what I hear all the time, right? This is why nobody trusts lawyers, and they all think that lawyers are fucking scumbags because of the dirty legal speak, right? They look in the camera and they're like, well, according to Clarence Thomas on the Supreme Court decision, and people's eyes cross, their eyes cloud, they're just done, right? They're like, fuck off, I don't want to hear this bullshit, it's nonsense, give it to me in plain speak. So I'll give it to you in plain speak. The law doesn't matter, power's what matters. That's the truth, is that power matters. In the last election, we had the power, conservatives did, and we put in Supreme Court justices that reflected the laws that we wanted to see, not the laws that stupid-ass, dirty progressives wanted to see. Now, I'm sorry that means we're going to make you behave, right? Oh, no, they're going to make us behave. They're going to make us pray in school. I mean, it's so terrible. So what are the terrible, horrific outcomes of this prayer? Well, I mean, it might lead to a more moral society. We know progressives hate that. They loathe it. It's their least favorite thing. But this is kind of what you always see in this back and forth with the left and the right, is that the left has somehow
religious people are so moral,
arbiters of what is moral and what is righteous and what is correct, and it's not true. The things that they advocate for are not moral, they're not righteous, and they're not correct. So what happens is we readjust. And we say, even if your interpretation of the law is this, we want it reinterpreted differently. There's nothing wrong with prayer in school. Nobody can make a great argument for why there is something wrong with prayer in school except because the Supreme Court says blah, 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 blah. That's it. There's nothing actually wrong with it, except that you might isolate this fringe minority, and everything that progressives do is always based around the infringements of like 3 fucking people, when the entirety of the nation, almost to a man, identifies as being a Christian. Do you think we're going to get our wires crossed or what? You got 330 million people, over 250 million of them describe themselves as being Christian. It's like, come on, enough of this shit. You people make us sick, literally, having these conversations with you. Anyway, that's my time.
Okay, I'm now going to throw it over to Ginger.
Okay. So I feel like they I don't think that they
Yeah,
were
he's
being
making up numbers,
hypocritical
by the
in
way,
sense
there.
saying that they
Yeah.
ruled in his favor. They still allow the Pledge of Allegiance, which says under God. We teach that to our students and have them say
Well,
that.
hopefully he gets sick
And
enough that
it's
maybe
not
he
required,
dies.
but we have them say that daily at school. I don't feel like being allowed to say the Pledge of Allegiance and then not being allowed to pray to that God is right in any sense of the word. But I do feel like there would be a very definitive difference if this had been any other religion. Had it not been him taking a knee to pray to God, had it been him, praying to Allah or whatever, this would have been a different outcome than it was. So in that sense, I feel like they're being hypocritical, but I don't necessarily think that he was doing anything wrong.
Okay, I am now going to throw it over to Frank.
Hey, so there seems to be a lot of confusion around the facts going back and forth between the two council, reading what the record was. So the one council seemed to establish that there were previous episodes where there was large prayers where all of the members could come in and pray together on the 50-yard line. It was not encouraged by him, but he said, hey, it's a free country if you want to join. So it was kind of closer to the long string of cases that we had for 70 years that seemed to suggest that you shouldn't be coercing in a broader sense, endorsing the religion and also coercing through peer pressure if people feel like I have to join in the prayer in order to get special time, perhaps. The court made some weird distinctions about showing whether or not the students actually did that or not, and there was some evidence that there were parents and students that were upset by that and felt that they had to comply with that prayer. I do think that on the other side, there were facts later that he was praying by himself. He had amended a lot of his behavior from his previous actions and was now individually praying, although it was still on the 50-yard line and it was still during the time that he was acting as an official of the school. I think generally, people don't seem to understand that this is good for religion also. I don't want a situation where I tell you that your religion is bad and that you don't get to pray. I think it's good that you have these the personal student's ability to pray. I think it's good that you could have a school administrator sit down and say grace while they're on their off time or when they're sitting at their desk not teaching. I think that's based and awesome. I want people to be able to enjoy their religions. I just think that if you articulate this broadly, you could have a scenario where I stand at the back of the class and loudly yell my religious prayer with the assumption that I'm not coercing anyone else to enjoy or to join me. However, eventually there will be students that feel pressured by that type of coercion, and I think it's important that the court is moving away from that and that has negative effects on students who have other denominations. So that's my opinion. I think religion, perfectly cool, and I don't think you should have one type of religion, which is what you might get if there's one teacher who is broadly praying and bringing other students into it.
Okay, that's all of the opening statements. Is there anybody that wants to start us off?
Yeah, I'd like to. I'd like to ask what the panel's thoughts are on scientism being taught as a religion and why it is that that's okay, that's perfectly acceptable, that
because there's
introduce...
fucking evidence that science exists.
Wait, Kevin. You gotta let him finish. If you disagree, you can say it.
There's fucking evidence that God exists. Did you not know that? That there's evidence that fucking God exists too?
There isn't.
You didn't know
there
that,
really
did
isn't.
you? There is. But
there
anyway,
isn't.
so back to scientism, right? No, there is.
No, well,
Even
there
philosophers
isn't.
will agree that there is evidence.
Well, no, there isn't. Okay.
You don't say
fine.
it's proof, but it's evidence. So anyway, back to where I was at before I was so rudely fucking interrupted by this fuck.
Shut the fuck up! Stop talking shit then. You're just talking absolute nonsense. Scientism isn't a fucking thing.
Scientism. One more time. If I don't want my kids to learn about evolution, I have to sign an exemption form. Now, probably nobody on this panel, with the exception of myself, has kids. Am I inaccurate about that? No.
I'm not a 33-year-old kid.
So. I don't think so. So you have to sign an exemption that says something along the lines of, I don't want them to learn this bullshit. So why is it that if you have a teacher that prays, you can't just sign the exemption and shut the fuck up like I have to do with your bullshit scientism?
Because scientism isn't a thing.
I want to give Kevin the priority to respond here.
Well, because scientism isn't a thing. That's just a nonsense that Christian bigots have invented to try and get around the fact that reality doesn't fucking agree with them.
Invented science, sir.
No, scientism.
No, they did. They really did invent science. I don't know what you're talking about. Yes,
the ancient Chinese were Christians, were
they? No, that's not the formal process for science, is it?
Okay, so at what point you just going to choose what?
I'm gonna choose the point in which the scientific process was invented and produced to the Catholic Church. Yeah, that's the point that I'm gonna go with.
Oh, you're a Catholic. That's an interesting one.
No, I'm not. I'm an Orthodox. I'm telling you.
Whoa. Formalized. Look, I gotta disagree with you a little bit there, right? Formalized process or methodology for how one determines how things work. Yeah, you can go back to Archimedes. You go back.
No. What I'm talking about, it's the modern scientific process, sir. That's it. That's all.
You're talking about the scientific
that's
method,
the distinction
right?
that I'm making. So one more time.
Also, by the way,
one more time? I'm going to tell you. Why is it that my kids, I have to sign an exemption for them to learn evolution when we don't believe that shit? We think that you're full of shit and you're all liars. We have to.
Well, hang on. Christians invented science, didn't they? So why have you got a problem with them teaching the Christian science of evolution, friend?
That's not a Christian science.
Oh, so you're just picking and choosing bits that you like and bits that you don't like?
No, of course.
Oh, because you're an idiot. Okay, fine, cool.
You're just making shit up as you go. Well, I don't understand. How is it a Christian science? Can you explain to me when Christians came up with the science of evolution?
Charles Darwin was a practicing Christian.
Christian. Are
yes,
you
he
out
was.
Of your mind? No, he wasn't.
Yes, he actually was.
Charles Darwin was.
If I'm not mistaken, he was Anglican.
Charles Darwin was a regular attendee of a Church of England church.
Anything. That doesn't mean he was a Christian.
Charles Darwin was a Christian, and actually after Charles Darwin was a Christian, after he came up with the theory of evolution, he then figured out people were trying to use it to try and push macroevolution, because he proved microevolution. He figured out people were trying to push macroevolution with it, and therefore denied the existence of God. He then spent the rest of his life trying to disprove microevolution, so that the way they couldn't do that. Charles Darwin, by his own words, was a Christian.
That's nice. Anybody can claim that they're anything that doesn't make them this thing. So one more time, I'm going to
picking and choosing Christians.
I'm ask you one more time, why is it that an exemption must be signed for us for your scientism, but not an exemption for prayer? These are two belief structures that are diametrically opposed to one another.
In your terms, the people in power don't consider that to be religious thought.
Oh,
you
well,
disagree,
so I agree with you. I think you make a great point that the people in power don't consider that religious thought, but I consider it to be dogmatic religious thought.
But power matters, motherfucker, and you don't have power.
Please let him finish.
Well, hold on.
Separate power out, and I'm going to put people in with power. Why is it that I would want to revoke the ability of people to have prayer in school? I wouldn't. That wouldn't make any sense.
What's the conversation about law and precedent, and you want to turn into a conversation about
precedent with
about prayer? You want to have a larger conversation about
argument, not a precedent-based argument. Can you do that for me?
You want to have a broader conversation about prayer and its usefulness.
Oh God,
and
everything's always a broader conversation. I'm being very specific.
You don't like the answer, right? So the people who make arguments in court don't consider evolution to be religious expression. They don't. Now, you don't have to like that answer. That's just the answer, and you can think that that's bullshit. But if I were to say something like math is religious expression, you would probably be like,
well,
maybe it is. But
I already agree with that greater point, and I concede that ground that the people in power who have the power over the institution of public schools.
It's a boring conversation. I mean,
probably do think this way. However, we're still talking about the concept of power. All of this is based around the concept of power.
You want to talk about that.
I'm asking you to give me a logical explanation.
You've hijacked the panel, which
well,
is
no, you're trying to hijack it by saying it's only legalistic. It's not. It's logical, it's spiritual, and it's the way that human beings
We're
operate.
talking
It's
about
not
the
simply
fucking Supreme
legalistic.
Court. How the fuck can it not be legal?
Supreme Court panel, and you hijacked it to have your own little diatribe about.
Well,
evolution
can I
is religious
disagree?
thought.
Can I
That's
disagree
cool,
with
bro.
the Supreme
That's
Court in
cool.
a non-legalistic way?
You can disagree with the Supreme Court all you
Great.
want, but the terms in which you're doing so aren't
And when
legal.
people,
I mean,
when people get put into power, sir, when people get put into power via my elected officials, they nominate the Supreme Court justices that are going to enforce my agenda. Do they not?
I'm glad you're conceding the law and saying this is just power politics. That's our point this whole time.
No,
It's all
no,
results
no. You're
oriented.
making legalistic arguments. That's separate from power. You can have power with no law.
I'm
What
glad
are you
you're
talking
conceding
about?
the law, and you're saying it's just about power. That's what we've been saying this whole time. That's
Also,
what
you don't-
Kevin Logan and we've been saying it's all.
But also, big
results-oriented, it's all
BPF,
power, and it's
BPF,
not
you
based on
don't
reason.
you don't have a leg to stand on here, because if it's all about power, the fact that those in power right now don't consider evolution to be religious thought is the end of the discussion. Because if it's just about
Well, no,
power,
it wouldn't
they've
be
made the
the
decision.
discussion.
Fuck
It
you.
would be a great way for
Fuck you.
me to begin to justify why it is that we want the power to swing in our direction, so
You
that we
want
can
reasons?
gain
You want to talk
more
about
power.
reasons? I thought you want to talk about power. If you
I'm
want to talk
sorry.
about reasons, we can
did-
talk
how
about
many
reasons.
how many of you fuckers do you want me to respond to at one time? Give me a chance with this asshole, and then I'll get right back to you.
Okay.
So one more time, let me ask you something. When we're talking about the exercise of power, isn't it appropriate for me, if I want more of it, to justify those reasons to sway as many people to my cause, since we have a democratic system, like I'm trying to do right now? So you can't just say, well,
Who are you
it's the
asking?
end of the discussion because we're in power, where you're not always going to be in fucking power, are you?
But yeah, do you not see how that works for you? Because you were going, well, they're enforcing my law now. How about we have a system called, I don't know, law, whereby it protects people from, say, evil cunts like you, who want to
makes the
impose
law?
their shit on everybody
Who
else?
makes the law? People in power, yeah.
Oh yeah,
boring
and
conversation
I
about,
agree with
like, I don't
Kevin
Okay,
Logan.
1 second. Okay, I'm gonna choose an order. So I want to go Jeb, and then I want to go to More Perfect Union because they've been waiting.
I agree with Kevin Logan. We should have a system called law that protects us from people forcing shit on other people, which is why I think it was really great that our Supreme Court did not allow the school to force this man to not be allowed to express his religion. And in the same way that, he got his private space he could have gone to, his prayer is allowed space, I would say that that is wrong for the same reason why Rosa Parks being able to sit on the back of the bus wasn't good enough.
Are you a clown?
I
Like
don't-
Are you a fucking clown?
Separate
No,
but equal.
hey, my
Separate
turn.
but-
Please,
My
separate
turn.
but equal, right?
He's been
So,
waiting.
I don't agree that creating a separate but equal space for him to pray is appropriate. I don't think that prayer in public is considered public prayer because it's not.
I thought your
because
well-regulated
you're allowed-
militia shtick
Hey,
was bad,
hey,
but this
hey.
is fucking rank.
Can
What are
I-
you
can I-
talking about?
Oh, if it's rank, then you'd let me keep going because it would just help you out, but you can't. So anyway, if a teacher goes
He's
into the
pretty
caf-
mad, Jeb Tan. He's pretty
is a
upset.
teacher, if a teacher goes into the
Go on, suck his dick
cafeteria-
harder, BPF.
if-
Go for it.
if a
Please,
te-
okay, please,
Hey!
okay, wait, okay. I'm fine with you guys sparring, but if it gets to a point where you're sparring over other people talking, I'm gonna shut it down.
But I just
okay?
want
I'm fine
BPF.
with a little fun.
I just want BPF to
Okay.
wank him off harder.
Okay.
Go on, jerk it
Hey.
hard. Go on.
Hey,
Okay, Kevin, I just said that it's annoying me, and you proceeded to then annoy me more.
You should probably do more arm exercises, Kevin.
Andrew,
Just to
now
be
you're
honest
annoying
with
me.
you.
Please,
Hey.
please.
Show
I
us
want
your
Jeb to
forearm.
be
Let
able
me
to
get
talk.
my
I want other
based-
people to talk.
Let me get my based ass point out. A teacher that eats their lunch in the cafeteria has the same right that a teacher that eats their lunch in their classroom to pray during that lunch, despite the fact that there are students there that may see it or even may take the charge to take part in it. Now, Franklin said something that I disagree with. He said it was established during the case that there was some level of coercion that seemed to manifest among the students, based on testimony that said they might have felt pressure to do it. I would argue that the ruling of the case shows that they actually established the opposite. They established that though there were some students that may have perceived things as coercive, what they determined was that there was no actual evidence of coercion. There was no manifestation of the kids who prayed being treated better than the kids who did not. And as we said, by the end of this, he was praying alone in the middle of the field. And you said it was also established that he was doing that as a representative of the school. But again, the decision in the case established that they believed he was not acting as a representative of the school.
We're disagreeing with it.
No, you're
That's
not.
what we're here to talk about.
Pisco, he didn't say he's disagreeing with it. He said it was established in the case.
I
that
said
that is
established
what
in the
happened.
record.
The facts. Come on.
Yes, and it wasn't established because
You can't argue the
for
facts
him,
and then say you disagree
he was
with the
no
opinion.
longer acting as a coach of a football team when he alone went into the middle of the field
disagrees.
and prayed.
That's
Yes,
the issue
what
in
I'm
the case. We're disagreeing.
Yes, but what I'm saying is, he was not coaching a football team when he went to go pray. He was not calling plays. He was not bringing kids into the huddle. He was not assigning positions. He was not giving any orders. He was going into the middle of the field, and he was praying. And just because he had the option to pray somewhere more private, and he still chose to pray in public, does not strip him of his right, just like nobody else outwardly protesting and outwardly expressing their civil rights in a public square because they feel that they have the right to have them, strips them of those rights.
I mean, you can still you can still have the right to pray without having to necessarily make it a public thing. Like you can say it in your.
But we don't have the rights.
Yeah, you can have the right to be.
We have the right in
making it a public thing too. But when are the liberals going to do that for us ever?
Yeah.
Well, hang on, as a Christian, surely you believe you agree with.
I don't think one has to do with the other,
Wait. I said.
Well, they're analogous. See, that's any analogy you make. Nothing's going to directly have anything to do with the other thing, but
It's your
it's
mic, Dylan.
analogous. That's how that works. So I'm saying
What's
to you,
an analogy?
you can't say you can't say this shit like, well, because it's public, it's wrong. It's like, okay, but if you were to take a poll on like public affection or things like this.
And it's not determined as public based on how many people see it. Public in the legal sense means state recognized. Private speech doesn't mean private like you not letting anybody see you. Private speech means your private speech that you have the right to as an individual. It does not mean you have to keep other people from seeing
that's
it. That's
worse for Kennedy.
Perfect union. Finally, there we go.
Yeah. So
He was interrupting, so we can interrupt him, right? I just wanted to make sure I was clear on the rules of the panel. That's all. He was making like a
the reason why was because I said he was going to be next, and then.
Oh, okay, gotcha. I didn't mean to interrupt you, by the way. Sorry about that.
That's not a problem.
Okay.
Okay, look, check it out.
I am sorry about interrupting.
Why don't you shut the fuck up?
In any case, the argument, right, that and I'm glad that Jeff Tan, that you brought it up. The separate but equal thing, right? They offered him a private place out of the way. That's separate. That's separate but equal, right? That's been struck down a long time ago. Just a couple quick points, right? The ruling was struck down on a number of issues. A couple of them were that Kennedy's prayers, they were considered to be private. You guys brought that up already. And that they're not, Jeff Tan, you also said this, they were not pursuant to his official duties. Okay. The other part is that the justification that Bremerton School District had for firing him was that they were using they used an establishment clause justification that was relying on, I guess, a case, Lemon v. Kurtzman, which was actually overturned before. Okay. So that decision was faulty. And that's the other primary reason why they dropped it down. Now, those things kind of helps people understand the balancing test was the thing in Kurtzman. But I got a question for you, because if you think that because you're in the middle of a game or at the end of the game, Pisco, for you, and then Ginger, a quick question for you. Do you think Tim Tebow, who was a student at Florida University that got federal dollars, do you think he should have been banned from playing because he exercised his freedom of religion by praying in the end zone? And then Ginger, you said that you're presupposing a different outcome based on a religious choice. I think when I did my opening, I said it doesn't matter if the person were a Muslim or Jew or Hindu or whatever. If they were exercising a First Amendment right to express themselves in a private prayer, I said in my opening that was not going to be a problem.
Nazi salute. Nazi salute.
One second. Godwin's law. Godwin's law.
Stop, please. Okay, so my question to you is, how can you say that you think You disagree with.
I
the,
don't think
the
he
rule
understands
because you
Godwin's
think
law either.
If the choice
Add
of
that to the
religious
list.
expression were different,
It's not
then there
just
would have
if
been
you
different
mention a
outcome.
Nazi
you have
thing.
no facts to support your evidence, but you sort of launch a defense of your side of the argument by basically saying, if only it were a different religion, the result would have been different. And I don't think you have any evidence to support that.
Was that to me?
Yeah, the last part was to you.
Oh, well, I did agree with their assessment, though.
Yeah, I realize, but I think you said that if it had been a Muslim prayer, or if it had been a different religion, you think the outcome would have been different.
I did say, in my personal opinion, I feel like that it would have been a different outcome. I don't feel like they would have given the same
deference on the facts.
But just
the different parties litigating it.
Jump in and savor, bro. Do it.
But just to be fair, you don't have any evidence to back that assertion, right? That's just a feeling.
You just said it's your intuition.
Yeah, I said it's my opinion. That means that it's
Okay.
not. It's probably.
To answer your question, and no, of course not. The actions of students who are the ones who are, on the sort of end of the conveyor belt of this education, it's never been upheld by this court to be an establishment clause violation for students to engage in prayer. We've always acknowledged that students are allowed to pray. To address the merits of the legal argument, which I'm glad we're getting at. You just saying that because a person is not actively giving coaching means that they're not in pursuit of their public duties is totally contravenes the court's prior holdings. I'm assuming that, at least not Andrew, but at least the other conservatives, you agree with the precedent that says teachers praying to kids actively, that would be a violation of the Establishment Clause, correct?
If it's
I
not
think
in the course of the curriculum, sure.
It depends on
I think unless it's optional, so such as like my school, and I'm sure other schools have this, to where a bunch of Christian athletes go out to a flagpole, and there'll be a couple teachers that are in charge of that kind of like club, and so they'll pray along the flagpole as well as the teachers. I think it's something
in the classroom. A teacher in the classroom.
No, not in the classroom. Not in the classroom. No, not in the classroom.
During
no.
classroom instruction, yeah, no, of course not.
Okay, so you think, because that's the basis of like this "don't say gay," quote unquote, "don't say gay" law in Florida, is that if it's within your duties, you're allowed to make content-based restrictions on class, right? Just like you can say, it's not a violation. I'm hoping you guys don't think it's a violation of the First Amendment to say you can't teach gender theory in class, right? And so I'm assuming you're okay with content-based restrictions in the classroom if they're in pursuit of their duties. The question is, like,
yeah, but if class is concluded, that teacher is praying, and students decide to stay in with her to pray, that would be okay.
You think that would be okay? So you think that our precedent supports the notion that
if
teachers
class
can stay in...
I don't care if precedent supports it. You asked me if I agree with precedent.
Okay.
I would agree with precedent that says during classroom instruction, you can't make kids pray during time where they have to be present with you and be listening to you actively. But if class is concluded, school is concluded, and you say, and they know, hey, this teacher, she actually goes to my church. I know she prays at the end of the day. I want to stick around and pray with her. If the teacher got fired for that, I'd be just as up in arms.
Yeah. On company time, in pump.
It's not on company time. Class is concluded.
Oh yeah, it is. Oh yeah, no, but you're still being paid. The coach is still being paid.
I mean, no, they're not hourly. They're not hourly employees.
So they were. The parties conceded that they were on company time.
Yeah, the coach conceded. The coach conceded that he was on company. The coach conceded that he was quote unquote on duty. And so when it come to that, what I'm gonna say is that I don't know if this is court precedent or this could just be state law. So forgive me if this is just state law. But at least in Indiana, students are able to bring up like religious concerns with the teachers, but the teachers are not able to bring it up with the student. So if I were to ask a teacher about like Christian theology or Muslim theology, the teacher can then feel free to engage with me in that conversation. But the teacher cannot bring it up to me. And so I think that rule can kind of be followed here, is that the teacher can't bring it up to the student, but should the student come up and say, "Hey, I want to pray with you," I think that's perfectly fine.
So now let's bring it forward a little bit. Even assuming that I agree with you, I don't agree with you. This is private speech. I think it's obviously that the coach is having an instructional role here. He has duties to make sure all the kids leave. I totally disagree with you on the notion of government speech versus private speech. But even if I agree with you that it's private speech, assume that's private speech. I'm gonna invoke this example. Suppose that we have a teacher who's teaching Islamism to kids in the same period you just told me. That's private speech between the kids in the school.
Osama's law.
Teachers teaching
Osama's law.
Islamism to these kids on their private time. Are the schools allowed to punish that teacher? Yes or no?
Yeah, instructing is different than expressing. Me
Again,
praying
it
is not-
depends.
Instructing
depends.
is different than expressing.
Okay, he's praying to in doing a prayer that's explicitly militant Islam.
I'm gonna stick to what I said.
Totally
And
fine.
I'm gonna say if the student brought it up to a teacher, then I don't see an issue with it. If the teacher brought it up to the student, then I see an issue with it.
No, it's private speech, right? So we already conceded that interaction was private speech for you guys. And so the teacher in this private speech moment comes up to the kid and says, hey, don't you want to join in this Wahhabist?
That would be seen as coercive. He said, don't you want to join
not
in?
Not based on this
no,
court.
Hold on. No, because
That's not true at
there's a
all.
mistake. The court did recognize that just because you are in a certain setting doesn't necessarily make something private speech, that the nature of the speech also takes part in it being
The
private speech
content of the
or not.
speech makes it. So the content of the speech makes. So if you
Yes, so
unfurl,
prayer is different than instruction. If you unfurl your prayer mat as a Muslim teacher and you pray after school and one of your Muslim students unfurls their mat next to you and prays along with you, because that is the time that you are both supposed to pray, that is fine. 100%.
This is not just freedom of religion. The court, as MPU said rightly, this is also a free speech case. So I am going to give you the Nazi salute example. So you're in the halftime, same facts, but instead of bowing your pray, you did the Nazi salute. You can't be sanctioned, right?
I mean, I agree with the right to religion part of this case. I don't necessarily agree that you can.
Well, then you're
Again.
logically inconsistent, Jebton.
No, not always.
Yeah,
no,
you
There
are,
are two
and
separate
this is why you
offenses
shouldn't
that were both
argue with
used in the
fucking
case.
legalists about the law.
Stop. No, don't. You can't give them the credit for this, man. Because
It's
you
okay,
can use a
schools-
freedom of religion.
You're fucking head
schools-
in, Jebton. I'm sorry.
No,
Schools-
you
wait,
can
schools-
use
Okay,
freedom of religion
okay.
in cases where you're
Jeb-Tan,
not
I'm trying to
doing
help
a general free speech argument.
Jeb-Tan, I'm trying to help you out and give you an
I know,
argument.
I
See,
don't
Yeah,
BPF's religion
so
is to do the
schools-
Nazi salute.
Schools
That's
most
why
of the
he's
time have
annoyed
moral
with
clauses
that.
in their contracts with teachers, to where if you break morals, then they are allowed to fire you. These do exist in teacher contracts more often than not.
Wait, but the district said you have to exhibit sportsmanlike conduct at all times. If you are a coach, you have to be a mentor and role model for student athletes. You have to maintain positive media relations, always approach with composure. Those sound like explicit parts of your duty that go beyond just,
I'm telling you, I'm telling you a Nazi salute would break the moral clause of a teacher contract.
Why? Why?
Why?
Because of what it stands for. Same reason of having a
Same
swastika.
logic.
Because we have established precedent that
Let me
religion
get
is
in. Let me
different
get
than
in for
general
just a
speech.
second.
Wait.
Calm down.
Okay. Wait,
So let me go over to Sprouticus, right? So I gotta ask you,
Wait.
why?
Hello?
Nazism.
Wait. Okay. Can you guys turn me up in Discord? Because
Yes,
I
I'm
put my mic on
turning you
max.
up.
Okay,
Yes, I'm
I'd
turning you up.
appreciate that. It's very difficult.
You're louder than he is. He's just talking over you.
Oh, I had you at 90%. That's my bad. That is my fault. I'm sorry. I have you at 150 now. I can hear you clear.
Okay, so I want to give people an order. Who wants to talk? I'm just going to give people an order.
Yeah,
Nobody interrupting anybody.
So
okay?
I'd like to get down to Sprouticus here and just ask him this.
One second, I'm going to
this
give an
pivotal-
order. Okay.
Well,
So
this is a
I'm gonna
pivotal
go.
question,
Give
Dylan.
me, well, let me give. Okay, it's pivotal. I understand that the world is in the balance. Let me just give an order. Okay, I want to write down names. So it's gonna go, Andrew, then Sprouticus. We're gonna respond. Then we're gonna go Kevin, then Jeb, in that order. Okay.
Yeah, whatever. I don't know. Anyway, Sprouticus, one more time. I gotta ask you. This is the crux of this guy's argument. He's asking you why, and any moral claim you make is going to be subjective. So this is the whole problem. You're engaging in legalism with this guy, and he's a fucking lawyer, right? This is, or at least he says he is, and we'll just grant that he is. But what I'm asking you is why? Why would that be, from your subjective standpoint, immoral? This is his entire claim, and I don't think you have anything for that, do you?
I do, and you wouldn't let me speak.
Now I'm going to let you speak.
Awesome. A Nazi salute is not part of a religion. I agree that this is a freedom of religion case, and the schools oftentimes have moral clauses in their contracts with teachers in which religion cannot be included.
So it was satanic.
So with this being said,
What if it was satanic and that's a recognized religion by the United States? Would that be okay?
That was the next question.
Albeit, it's a religious freedom.
So,
not a Nazi salute.
but the thing is that it's still, if you're looking at it from a moral or ethical standpoint, that should still be just as unethical to you as the Nazi salute. Why don't you fucking guys get this? Why don't you understand what he's saying?
You don't think that like schools
just
should ban? You don't think schools should be able to ban satanic prayers in the middle of their field? No, you don't. So we're gonna have courts now. So you guys who are afraid of political courts, we're gonna have courts go into the sincerity of religion and be doing ecclesiastical tests to find out which are the real religions and which are the fake religions that are more political. Is that really what you want?
No, he's literally saying not to do that. He's specifically saying not to do that.
Oh wait, but I heard you say that you would allow satanic prayer in the half field.
Yes, he said he's not putting it up to an ecclesiastical test to see if it's sincere or not. He's saying he
So
would
if
allow
I
it
said I
because
have a
of
Nazi religion, so suppose I said Nazi religion, you can't test the sincerity.
I mean, what's the standard now?
You just said you wouldn't have it.
What is the standard now for religious
freedom? Who cares what the standard is right now?
I do.
I'm actually curious too. What's the standard?
No, I'm asking you. Who cares what the standard is right this second? If we're looking at it from a okay, but if we're looking at it from a hypothetical, let's say it was the standard.
Let him answer.
So you just told me. So Sprouticus, you just and also Jeb said that there's not going to be a sincerity test on the religion. So someone says it's my Nazi religion that I go out there and do the Nazi salute. It's my religion. I believe.
I tell you what. I base my standard on what the Supreme Court has ruled for in freedom of religion cases, and Satanism. Satanism has won freedom of religion cases in courts before there is precedent for Satanism winning freedom of religion cases. And so, with that being said, I would see Satanism.
You're going to test sincerity, right?
There's obviously some standard for sincerity, as you're not going to get away with murder because it's quote unquote part of your religion.
Well, look, Andrew's
standards as they exist.
Look, Andrew's sincere religious belief is Nazism. So why are you oppressing him by not allowing him to do the Nazi salute on the halfway line?
I'm sorry. Did you just level an allegation at me? I think for certain that your religious belief is pedophilia, sir.
Yeah.
And I can. And
yeah,
I
why
think
not?
so
Fuck it, go
because
for it.
you clearly have a pedophilic flag behind you right this second, right?
Let's not do any sincerity testing on any of those points.
Yeah. So great. So don't
I don't
call
want to
me.
see how sincere he is or isn't.
So before you get into Nazism and blah blah blah, which is all bullshit and nonsense, and you just trying to throw shade because you have no arguments. At this
well, no, I'm just mocking you because you're nothing. You're literally
I'm actually
nothing.
agreeing with your side. Because I'm saying that this is an all or nothing, winner takes all type scenario. And so what happens is the right wing tends to decide that, well, we'll fracture this and we'll say some of it's okay, some of it's not okay. And that enter the lawyer, he comes in, he picks it to fucking pieces, as well they should, because it's not consistent. So just be fucking consistent. That's all I'm asking for. Just be consistent with what it is that you think.
Okay, next is going to be Jeb, and then it's going to be Ginger.
Man, this has gone so many places. But I was told there was an argument given for me that was going to strengthen my argument, and I think it honestly got us more and more in the weeds. Again, fundamentally, we have the right to freedom of religion. That is something that persists through everything. Like you said, the moral codes cannot have religion implied in them. You can't imply that some sort of religious conduct is against the moral code if it is specifically enumerated in someone's religion. You can't have a ban against praying on a mat in your moral code because someone is Muslim and you don't want them to pray a Muslim prayer. When I tried to ask a question when everybody jumped in on me. Is the protection of your right to religion separate from your protection of your right to free speech? And I know the answer. I don't need anyone to answer it. The answer is yes. It 100% is. And it extends much farther. I agree with the right to religion aspect of this case. I don't necessarily care about the right to free speech because, again, while it may be sufficient, it isn't necessary. You could be without the right to free speech argument. You would still have the right to religious argument, and it would be sufficient for this case. Still, because he had the right to religion in that circumstance. He was not instructing that religion to anybody. He was freely expressing that religion around people, but it was still private speech. You are allowed to pray, even on public time, because circumstances can determine private speech, but so can content of the speech.
The thing is, it doesn't help you, because even the right of free expression of religion is not unlimited. if there's, first of all, if there's neutral laws of general applicability, right? Let's say that your religion says that you can have human sacrifice. Those are actual religions. They're human sacrifice. The government's allowed to regulate that stuff, even though it would like technically infringe on your freedom of expression of religion. And even in the case of beliefs as such and displays as such, you can imagine religious prayers, speeches that are so disruptive that they just shut down the function of our societies. Or schools have like let's say that you actually believe, Andrew, and you think that scientism is a religion, or that you think that and people recognize it as a religion, or people think that gender theory is a religion. Let's say that you accept that.
It's coming.
And then they said, that's my religious
I'm
expression.
coming too.
Now, that stuff, and teaching that stuff, and having, discourse on that stuff that you hate would be protected under the religion clauses. Like, that can't be allowed. Like,
you're right. So the standard you said is it's so disruptive, it's going to break everything apart, and it's going to result in material coercion among students, and it didn't. There was no evidence of unequal treatment toward the students that did participate in the prayer.
The test isn't,
it didn't interrupt anything.
The test isn't it didn't. In fact, if that was the test, then like you could just have people who, by virtue of circumstance are all Christian, and so that your prayer didn't really move the ball on them because they were all going to pray anyway. But it would still violate.
You have to show harm. The students would have to show harm in that particular case.
Prayer on public time in non-instructional circumstances has been upheld as something that is okay.
Prayer banners in gymnasiums have not been upheld.
Okay, he didn't put up a prayer banner in gymnasium. He prayed
I know
alone.
He didn't.
He amended his conduct so much to the point that he was just simply praying at the half line on his half point, at the middle of the field.
Do you agree with his lawyers?
No one around.
Yeah, do you agree with his lawyers that his previous conduct would violate the First Amendment? Because that's what they said. They agreed that his previous conduct would violate the First Amendment.
I don't care.
But he modified his conduct and they didn't fire him for his prior
you agree that his
him.
previous conduct, right? His big group prayers, all his locker room prayers.
No, I don't care.
So you disagree with
that.
But it doesn't matter. Tell me why his end conduct he got fired for was against the First Amendment, because that is what would be necessary for your argument for this.
As Andrew said, they suspended him. They fired.
They fired.
May I?
He got fired.
No. He's about to answer something. Hold on. Tell me where.
I will give you my affirmative answer, but I just want to be clear.
Okay.
Your answer needs to be consistent throughout your argument, and if not, I'm just going to show you its inconsistencies. And that's why I want to establish beforehand if you agree with his own lawyers that his previous conduct violates the Establishment Clause. And if you don't agree with that, then I'm gonna give you an even more stark example.
Can you hear this fucking cat?
I don't, and this is why. My stated opinion on this is going to be that it is irrelevant because he was not suspended for that conduct. So
I can't ask you hypotheticals.
Yes, that's my point. I'm trying to get you to prove why him being suspended for the conduct. That's what he was suspended for. That's what the case is pertaining to.
No, the cat's outside. He wants in.
Or is not just making.
That's what the ruling was based on. Yes.
You can't have it both ways, Pisco. He wasn't terminated for the prior conduct.
Yes,
you're not even answering the question. You're not even answering the question whether or not.
I'm telling you to answer my question finally.
I will, but
what
will you
about
answer mine?
the end No, because I don't think it's relevant.
Wait, so you'll never answer hypos in this conversation about the law?
No, I'll answer some, but relevant ones. They're not relevant because that's not what he was terminated for.
Answer them too, Pisco.
May
Okay, I'll give you your answer, and then everyone's gonna see that you're being a little I don't know, weasel.
I'm not. I'm not being a weasel. I'm telling you to keep it on what the case was about, which was his conduct at the end and his suspension for it.
So you're not going to answer in hypo whether or not his previous conduct would violate the Establishment Clause.
I will after we establish whether or not they were right to suspend him, which is what the case was brought to the Supreme Court for.
I'll tell you why. First of all, none of this speech is protected. Number one, because it's obviously government speech. This is within the scope of his employment. His explicit contract talks about how he has to be a positive role model for the kids. He was on the clock. He was having duties to take care of the field, make sure all the kids were getting off the field. The previous 8 years of his prayers informed his current conduct, where he was doing all the things that his own lawyers concede what would be in his official duties. And so because it's public speech, it's clear that both Pickering analysis, which is the free speech analysis, and the relevant free expression analysis doesn't apply. But even if it were private speech, I would say there's a legitimate interest in the role of the state to prevent an Establishment Clause violation. And this would be an Establishment Clause violation. It is coercive of students. So
but again, there was no evidence of coercion.
Actual coercion.
Now, will you actually? No. Well, hang on. First of all, that fact record is highly disputed,
Yes.
and you can say like I just read the majority and I accept all their facts as they take them. That's like okay, that's fine. They disagree. I disagree. That's what we're here for, to disagree on the relevance, the significance of the fact. That's what being a lawyer and interpreting law, and that's all about. It's about disagreeing, okay, and distinguishing. And so I disagree with their established facts. By the way, a lot of people do too. I agree more with the dissent's theory. Now that I've answered your question on two separate independent grounds why I think they're totally free to sanction them. One, because it's public speech, so it's not protected. And second, because I think even if it is private speech, we have to prevent Establishment Clause violations. That's a significant interest of the state. And so the Pickering analysis there, it fails for Mr. Kennedy. Now will you answer whether you agree with Mr. Kennedy's lawyers that his previous conduct would violate the Establishment Clause?
It depends at what point you're talking about. I think it was to the, I forgot exactly what the timeline was of the beginning of his remedy, but there was a point at which he was simply going to the middle of the field to pray. There was an understanding that's what he was going to do, but he wasn't calling students to come join him, but students were still coming to join him. I think that would be a violation of his First Amendment right to freedom of religion to fire him for that. I agree that the promotion.
Lawyers disagree with them. The lawyers say all that the locker room speeches and the religious prayers directly to the students. The coach agrees that the lawyers agree. Establishment Clause violations under well-settled precedent. Do you agree with that determination by Mr. Kennedy's own lawyers?
I disagree with the second, the prayers to students. I disagree with that. I don't disagree with the locker room instruction, because that is a point at which the students, they have to be in that locker room. They have to be listening to him. And he was choosing to speak on that time. That is public speech.
A public paid coach, they're allowed to lead a prayer for students, but a public teacher is not allowed to lead a prayer for students. Am I getting that right?
No, because public teachers are allowed to lead prayers for students in certain circumstances, even on compensated time.
Context when they're coaching, right? So he's coaching and he's saying, "We just won the game. I just want to take this time right now for us to pray and thank God for our victory today." Imagine a similar case in the classroom. In the classroom, you agree that would be banned, but now in the coaching context, banned or not banned?
No, I don't agree, because again, at the point at which the game is over, that is the point at which class is over in the parallel in my mind. So if class is over, and I said if someone lays out their mat to pray and another student gets next
the
to
class
them and
isn't
lays out their
over.
mat to
The
pray
final
too,
whistle
that
is
would
for
be a
me,
violation of
not
their
for
religious
you.
liberties to fire them.
Classroom ends. Teacher says, "Everyone gather around. Let's all have a prayer." You think
I specifically said that the point at which he was going to pray and kids were choosing to go pray with him, I believe it would be a violation of his religious liberty.
What would be coercive? I mean, the whole point of coercive is to not explicit forcing. The whole doctrine of coerciveness is getting that not explicit forcing. And so if me, leading the class in a prayer, even when I'm saying like you don't technically have to join, isn't coercive, then nothing is coercive. I mean, what would be coercive?
No, that's not true. No, that's not true.
So you're saying right now that
Pisco, what was the actual coercion
in this particular case?
Yeah,
offering an opportunity with the specific condition that they know that they don't have to join, and he explicitly says that they don't have to join is not coercion.
We're talking about the fact pattern before the second.
No, we're actually discussing this case. So you keep wanting to
I
go
was
back.
referencing
You
the
want
other
to go into
cases.
prior. No, you want to keep going back to the prior conduct.
Because I care about like logic and reasoning.
I get what you're trying to do.
He believes in logicism.
Shows no.
He believes in the scientism of logicism.
Really?
No, in the beginning there was. That was not the complaint that was filed to the court. The complaint that was filed to the court was not underneath those pretexts by either party.
If all the kids said that this was coercive, if all the kids,
I think I might just quote Jesus. I think
in
in my outro, I'm just going to quote Jesus about being a hypocrite.
Had all like gone to the court and during factual development for summary judgment had all said we all felt coerced. Would you be like, okay, it was coercive?
If there was a finding by the court that it was coercive, sure.
So it's subjective coerciveness, not not an objective test. It's a subjective test. Were they in fact coerced? Not was the action dangerous to coerce?
You have to show actual harm. I can't just go in and say Pisco
Oh,
coerced me to change my argument.
No, you actually don't.
There has
No.
to be some evidence
You don't
that
at
there was
all.
actual
This is
coercion
not a
applied.
civil-
It's crazy how wrong you are.
If you don't
because
come pray with me on the 50-yard line, I'm going to bench you next game.
It's crazy
Right?
how wrong
There
you
was
are.
no, there was no objective coercion. That's
It's
reported
crazy how
in this
wrong you
case.
are.
Yeah, Wayward, I've got the quote
Usually
from,
you do have to prove
hang on.
damages, right? Usually you do have to prove
No, you have to prove
From
harm.
Matthew, it's
and then
quoting
you leave
Jesus
it.
on the
Come
Sermon
on,
on the
are you really
Mount.
Stop, okay? Harm, damages. You're
When
not
you
gonna be-
pray,
you're
you
gonna
shall
get mad
not
at me
be
for,
as the
like,
hypocrites.
Getting you for the Google thing. Do not get mad at, or I don't know if you got mad at that.
No,
PPF.
look,
That was
okay,
okay.
if you're saying harm, if you're saying damage means harm, fine, I got no problem.
Okay. Usually you have to prove damages or some kind of like thing that's going to happen to you. But establishment clause cases, like one of the few breeds of cases where you don't actually have to show a burden of harm. That's like one of the cases in which it's unique that you don't have to show that harm, and that
So
it's just
I can say I've been coerced, but not actually have to show that I was coerced.
it's coercive,
I
right?
can just. It's coercive only if you feel coerced.
So you're saying it is a subjective test. So if there were,
It's
you're okay
subjective
with
to the
prayer.
person who
I think
feels
he's
coerced,
arguing
sure.
it's fundamental. I think he's arguing that the idea of coercion itself is fundamentally subjective. I think is his argument.
But it's an objective. It should be an objective test, shouldn't it?
Yeah, I think that's what he's arguing is that coercion
want
might be a
conduct-
bad test.
Oh,
We
wait,
want conduct to be
should it be an objective test?
It should, right?
Oh,
When I say
well,
objective-
okay.
Well, then how can you
You're
have an
trading a
objective
test.
test?
Wait, should it be an objective test?
Yeah, if
Let's just
I
be
am
clear what I
not-
mean by
if
objective.
I am
So
not
objective-
actually harmed, meaning like for me to feel coerced about not being able to play if I don't pray, okay, then I literally have to be benched and no other reason exists for me
No.
to bullshit.
That's not what
Hang on, let me
that's not what
finish.
we're talking about.
Let me finish. Okay, if I'm gonna say I feel like I was coerced if I didn't
I
go
am
out there and pray,
sweating.
I felt like I was gonna be forced to sit down. That's asking somebody to disprove a negative.
So first of all, three people I think or said that they were, and so I don't know.
Not in this case.
Yeah, that's crazy. There's like how many people on a football team?
Okay, so now it's not just one person. So before you was like, show me
If one
coercion.
person decides that they're coerced in one situation where the vast majority don't, I don't think that meets the.
Well,
that should
Well,
be-
not just that, but you
Jesus
said,
What
you
if
said
they
this
all-
needs to be objective, right?
Yes.
This-
When you say an objective test in the law, what you're saying is it doesn't depend on the subjective actual coerciveness. You take this is the reasonable person test, right? When you're analyzing.
It's
tort
okay
law,
if they
what's a reasonable
just
person
infringe
to
the
do?
rights of a
That's
few
objectiveness
people.
about it. And
That's
so Usually we
fine.
want like all of our schools to have the same establishment.
As long
clause
as it's
standard.
like,
If you're like
less
oh,
than
it might be
20% of the
different
people,
depending
let's
on
just
how many-
infringe their rights. Fuck them.
You want the religion clauses to be totally random based on your.
Oh well, if you're talking about public schools, yeah, then I
Yeah.
agree.
Yeah,
We're only
let
talking
me-
about public schools, asshole.
Okay.
This is the establishment clause.
Yeah,
Okay,
you would
well,
agree with that?
hey, I'm just
Why you would
clarifying.
agree
You
to
said
that?
all of our schools. I was like, I don't think anybody wants all of our schools to be held. to
Okay,
that
my
standard.
bad. I
Yeah.
should have public schools.
Why don't we put a hypothetical out here because you did differentiate if one person objects. So let's say
Yeah.
everybody on the team was Christian and one student was Muslim and they felt coerced to join in because they were not part of that religion. However, they felt, oh, well, this might actually affect my playtime. I'll feel like I'm isolated from the rest of the team. People might haze me. I don't feel the coach is supporting me anymore. Those are things that one student, it would be very relevant to.
Yeah.
Yeah.
It would be relevant, but I think that you still couldn't make a decision on whether it was coercive until you address the content of the speech. Which, if the content of the speech shows an active attempt to ensure the lack of coercion, aka specifically stating you do not have to participate, there will be no punishment for not
There's a mens rea
participating.
requirement. so it needs to be intentionally coercive.
Can I give an
Can it be-
example?
Does it have to be
No.
intentionally
Hold
coercive?
on. It doesn't have to be intentionally coercive, but if you show an intentional effort to be non-coercive, I think that can aid in your argument
That's a get
against
out of jail
coercion.
free card. So you say,
Can I-
hey guys, not coercive, wink, and then you can do whatever you want.
Okay,
Can I
well,
give
that-
an
No,
example?
no,
Can
no,
I-
you can't do
would
whatever.
be
No,
considered
stop. He's asking me a question. This is perfect. That's where we have to incorporate whether there was evidence that even though they were saying there was no coercion, that there was still a punishment possibly levied against the students. So was there a difference in playtime from the kids who? But no, you can't just say, oh, because he said this is not coercion and I think he's lying, it's coercion. No, that's where you would definitely have to show, okay, well, he gave the this isn't coercion winky face, but it's pretty clear that the kids weren't getting the playing time. Like, I don't think
this is
yeah, but this also opens up.
So I've got a question.
I'm muted, so I'm not
student
talking.
Standard should not be the standard, just blanket carried out in every
But
circumstance.
this opens up other cases, doesn't it?
No, I agree. It should be an
in the future, because this is the precedent that's been set.
Student, but you want to say like
yes, and I think no, I agree because I think no. I agree. I think the reasonable student that is told explicitly there will be no punishment and has seen no punishment levied on other students would agree, and that is why the majority of the football team did not testify that they were coerced, and only 3 did, because I think the reasonable student would not believe it was coercive, and that is how it panned out.
I totally disagree with you.
You think if 3 people of a group of at least 22 students, you think 3 people out of that big group is evidence that the reasonable person would definitely be coerced, and not necessarily that maybe a more unreasonable person would be coerced?
So the fact that you have students who
don't raise your hands, proud of kiss. Just cut in like a man. You know, just cut in like a man. Don't raise your hand.
I think he's respecting the good back and forth. I think.
The fact that you have students who may already be that religion, the fact that they might say like, yeah, it's not coercive because I am Christian, just like Slash said, right? It's not coercive for me. I'm already this religion. I already want to pray. I already do pray. So our denominator can't be people who are like agree with you. The denominator has to be, is it coercive for people who are not of that religion? Shouldn't it?
I mean, yeah, but that's not bona fide the case here. That wasn't found.
Don't we need no more facts?
That's what I'm saying is incorporate more facts. But then you said that's become subjective, and if we incorporate that many, we're making it subjective. I think the objective standard should be that if you show an insistent effort to make it non-coercive by specifically stating that there will be no consequences and following that up by treating all of the students fairly, that objectively you have shown that you are not being coercive because you went out of your way to make sure they knew that they didn't need to do it, and you went out of your way to treat them all fairly.
I have something to say in regards to this. I feel like the example that he's leading by kind of, and I'm sure I'm gonna get shit for this, but by peacocking his religion, when he can so easily do it quietly and to himself without causing a scene, is coercive in itself, because the Bible
you said the same thing about homosexuality. I'm just curious,
Bible,
like if you
wait, Andrew, you gotta let her finish first.
Well, would that be fucking someone on the halfway line?
No, wait. Why do I need to let her finish? Like, because why isn't it pertinent for me to cut in at the?
Okay. So the Bible teaches Christians to announce their faith, to lead by example, and in that you are trying to deter people from their original thought to the thought of yours. That's pretty much what the Bible teaches, so that's the way that we teach our word and we live by example. So instead of this guy going home to pray, to bend the knee and pray or whatever, or going into his office or whatever to do this, which he could have done.
Was that in Psalms just made that shit up on the spot, or where can you reference that that's what the Bible teaches, Ginger?
That the Bible teaches you that
I can quote it.
Don't save her. Everybody always wants to save the chick. Just let her fucking answer.
You won't let me answer. That? How are they supposed to let me answer?
I'm letting you answer. He cut in on me.
I'm actually gonna just not answer him.
Of course you're not, because you don't know the answer, right?
No,
Where does it say that?
I do.
Well, then say it.
I've got a response to the concern.
Would you let Ginger answer my question? We let you guys go on a back and forth forever.
She said she's not gonna, though.
Okay,
I gotten to ask Pisco my question, so
she said she's not. She said she's not going to. So I just want to respond to the concern.
Let me inquire with her like you were just doing with Pisco. Can you tell me, Ginger, from your perspective, where the Bible says these things?
To lead by example?
Yeah, anything that
to substantiate. I can direct.
Literally any of the things that you just said. Can you tell me biblically where any of those things are substantiated?
It says it throughout the Bible, actually.
I can.
These guys, everybody always jumps the fuck in, you know.
There's Corinthians, there's Timothy,
Paul.
there's Matthew, there's Luke and John.
Yeah, I'm not asking you about all the books in the Bible. I'm asking you specifically, can you
Those are the books in the
substantiate your
Bible. They're
claims?
the things that I brought up.
Yeah, where though?
Oh, well, I can
I know,
give you a direct
She's a
quote.
scholar. Who
She
cares?
was responding to me, so I want to respond to the concern, which is that if we hold
Well, can I
Christianity
get-
to a different standard based on its evangelism, we're
Jump in,
sort of
you have a
fundamentally
reputation
treating
for
it
it.
differently than any other religion, just due to the nature of the
Yeah, you
religion,
would if you had a
which we wouldn't
religion that
allow.
was like, if you had a religion about child sacrifice, you treat it differently. You treat
Yeah,
different
but
things
again-
differently.
But that's not. But again, in this context, we're not talking about sacrificing children. We're talking about the possible implied intent
And
of
you
a
guys
prayer
are crazy people who would let Satanists pray in the middle of your field, and you wouldn't distinguish based on religions. I guess I'm not.
Well, I
I'm
mean,
not
it
crazy about
obviously it
that.
depends on what they do, but no, if they're just taking a knee and saying, "Dear
No.
Satan, please help us win the next game and defeat everybody and give us a good life," no, I don't think you should be able to fire them for that. But
What
if
do you think
they're
about that,
saying-
Andrew? What do you think
if
about
they're
that Christian
saying-
theology?
If they're saying,
I've got a
"Sail
question
Hayton,
for you.
murder everybody, kill all the
Yeah.
kids, we're gonna go gut a lamb later," then yeah, I would say maybe a little bit because of the potential harm of gutting a lamb in front of everybody. Yeah.
So Pisco, I've got a question. For you, Pisco. So from my understanding, and I could be wrong, so correct me if I'm wrong, but from my understanding, the coach that we're referring to was an assistant coach, and he was not the head coach, and he wasn't in charge of time. Are any of those statements incorrect?
I don't think those statements are incorrect. I don't think he was a head coach. I think you're right on the facts.
So with that being said, because I've wanted to say this for a while, but it's just been so much. But with that being said, I'm not really sure why we're debating. Like I've heard people debate this like coercively, saying that time was a factor. When this coach didn't even have control of the time, he wasn't the head coach; he was an assistant coach. And so
No, I mean
stuff
company
like that.
time. Like he was on the job.
No. They're talking about playing time. So I forget who
No,
was
I'm
talking
not.
playing
No.
time.
The prayers for the purposes of the litigation. What's his name? Jebtan is correct. That the purpose of litigation, the majority assumed that you're not talking about the previous stuff. You're talking about the current stuff, and that stuff was all after the game was over, after the game was done. And so that's the kind of facts that I'm going off of. And your question is such a good one because it gets the heart. Oh my God, my law degree just fucking slammed. Okay, who made Andrew? You fucker.
I did this to you. Remember this, and remember the fact that you're slouching
broken-
down. You're slouching down right now in defeat.
True.
Right?
Okay,
Sit
listen.
the fuck up.
So, your question is a really good one. It's a really good one because I would have a different standard for like the janitor. If the janitor wants to have like a private prayer, I'm not going to do the same analysis where I'm like, he has an instructional role, that he's media facing. It's just a different nature of position. Just like there's ministerial exceptions for the for like civil rights laws and employment laws. So there are ministerial exceptions. If you're a minister in this country, you can discriminate on the basis of sex, right? If you're a Catholic priest, you can say that women aren't allowed. That's a ministerial exception to the free that's sort of found in the free exercise clause. And so based on your role, the Supreme Court has decided that different rules apply. And that makes sense because we don't necessarily want the church going in and deciding who's a pastor. Imagine if the church was like, you have to allow women and gays into your like Catholic priesthood.
You just said that we shouldn't allow the church to decide who are pastors.
No, what I'm saying is the court has recognized that it would seem weird if the federal government were to say something like, the Catholic Church must allow gay people and women to be priests.
Okay,
that's a ministerial exception based on the role of the employer.
You said something I just want to touch on. You said a janitor. You said if a janitor were doing it, you wouldn't have a problem with it as compared to a coach because of the difference in their roles. Is that correct?
Yeah, it would change the scope of their duties, right?
Doesn't that create a disproportionate or unequal application of the law?
No,
that's not a 14th Amendment
it changes
violation.
the scope. It changes the scope. It's not an equal protection issue. And I heard that a little bit too. The separate but equal stuff, that is not at issue here. Okay, just excise that from your brain. Doesn't apply.
Well, no, I was talking about KF Logan bringing up that they gave him like a little private prayer room and he chose not to use it.
No,
that
but
was the reason I
that would
made
make sense given Kevin's statement makes complete sense in the if you're analyzing the scope of what is in their duties, right? I think a lot of people would feel bad about banning like a janitor from wearing a crucifix or something like that, right? That's not, we don't think of them wearing that symbol like underneath their shirt while they don't have a public facing role. They
Yeah,
don't,
they
we
were.
feel a little better.
They were trying to make. They were trying to make a
think-
reasonable accommodation to allow him to have his religious practice, but also not break the law. Like they were just trying to
Pisco,
be reasonable.
I don't think you should be able to ban anyone disregarding the role of wearing a crucifix.
Job.
Okay,
It's
maybe
a
you think
job,
a maybe you think a crucifix is like
No, you can't do
so-
that. You,
But what?
You cannot ban the free
What is
exercise
their job?
of
What does that have to do with anything?
Yeah.
no, it has total
free
implications. Like
exercise
if you take a public job, it totally matters how you comport. You're taking that employment on conditions. You can't just be, giving out. If you're a Jehovah's Witness, and assuming you have a government job or something, you can't hand out your flyers on the job. You
Yeah,
can't.
but the example,
you can
was the
crucifix,
wearing.
though.
The example was the wearing of a crucifix.
As applied, the crucifix.
Catholic expression of one's religion, such as wearing a crucifix, cannot be used.
Well,
as a
no,
ban.
I mean, but hang on. I want this logically explained. Can you logically explain to me how somebody would be barred from doing their job or would do their job poorly because they're wearing a crucifix?
Let's say that they're. Are you asking me? Or are you asking? I don't know.
I'm asking you.
I can't think of a lot of situations
Right.
in which a crucifix
Could
would
they have
be,
it tattooed on them?
It would be in the
Pisco?
scope.
Could they have it
Hang on.
tattooed on them, Pisco? Is that
Let him, let him
Yeah.
finish, because I think he was about to say he can't think of a lot of times. where
It's fine. It's good. Let us have some back and forth. Relax. Go ahead.
In terms of like a cross, I can think of certain religious displays that would be so difficult to coincide with how you run your workplace. Let's say that you were wearing, some religious display like a Satanist garb, or let's say that you are a Pastafarian and you're wearing like a, I don't know, what are those called?
Colander.
The
Colander.
trainers, right? Trainers.
Yes.
To the crucifix before you go off on a diatribe. Just the crucifix.
I'm about to distinguish those cases where I can think of some religious displays which are so weird that people wouldn't go to your
We're not talking about
government
those.
office. The crucifix, I think,
Mm-hmm.
has been sort of accepted and wouldn't. I can't think of situations. Maybe they would. Maybe if like a judge was wearing it and they're supposed to be equal before the law, I would have a problem with it.
What if the judge had a tattoo of a crucifix?
I think it would be a problem, right? Let's say like if your job is to be a judge and to be impartial, and that's why you wear black robes. I can think of having any kind of religious display, including hijab, where that could be problematic.
Yeah, but okay, so back to
Line
the
drawing. There's a line drawing problem here, Andrew. I'm not going to lie to you. There are some cases which are hard cases, and some cases which are easier cases. And
right. So we're back to subjectivity again, right?
But what are you going to say, Andrew? All religious displays are allowed? Or are you going to say that Satanists are allowed to wear their stuff?
Well, no, but again, if we're going to be
You're line drawing
consistent,
too. You're line drawing too.
hang on, if we're going to be consistent, right? We would have to say that though, right?
No, not if you have a rule of like disruption and you have some. Now, at some level of analyzing what's a disruption.
Even if you had the rule of disruption, everything would have to fall into it, or nothing would, right?
That's what we have like courts and judges for, and reasonability.
This is my whole point. Is that all of this?
Based on reasonability.
Listen, Pisco, calm down. Let me just explain. The entirety of this conversation has been very surface level, revolving around a singular case. It's not really getting to the heart of the issue, and the heart of the issue is whether or not we're able to have an all or nothing situation in these particular instances. Right. Well, from your perspective, you say no, right? And this creates conflict.
But you wouldn't either. You and I agree.
I don't know. I don't think I only agreed with you on the consistency or the lack of consistency of your opponent's argument. You didn't agree with your prescriptions.
Let me ask you your rule. You would let Satanists and Nazis and any kind of religious display, or even free speech display for that matter,
be completely consistent, and I would only allow Christian symbolism, period.
What kind of Christian symbolism?
Oh, well, I would not Roman. One more time, I'm not a fucking Catholic. How many times I got to say this? Not a Catholic. I'm an Orthodox Christian.
Some religious displays you would consider to be like heresy, right? And it wouldn't.
Yeah.
Like those.
So, well, absolutely, and I think that those are detrimental to the public as well.
Right? That's kind of subjective.
Well, who decides it now, right?
No. You still have a.
You know what I mean? People decide it now. Hang on, Pisco, relax, calm down. Let me get a word in. I'll let you get a word in too. What I'm saying to you is that just because you're consistent with the application, now you make the argument, well, who allows it? Well, who allows it now? Whoever's in the control grid for power is who allows or disallows these things. But for the best possible outcome from all you likely utilitarians on the panel, having a singular religion is probably the best for everybody, isn't it?
So you would apply, I don't agree with that. You would apply a rule, a different rule, but the rule would be subjective in the same way, you know, a rule about
it would be
destruction.
objective. You can objectively apply it. Why
No,
couldn't
you
you?
can't.
Why
Because-
couldn't you?
Because there are going to be edge cases on the heresy front as well.
It's the edge
I
case.
do want to
Edge
say
case.
I do want to say you could have an objective standard that would
course you
apply
could.
specific facts to a given scenario. The issue is you can't have like a objective standard that is solely one answer always, or else it's not a standard anymore. It is an application of a direct.
But what would that be? What would that actually be, Franklin?
It's called an edict.
If you said something like no profane religious displays, or
Yeah.
something, or some rule like that,
You'd have to look
someone
at general
is deciding what's profane,
circumstances.
right?
Yeah, but somebody's
You'd have to look
deciding
at
everything right now.
Yes,
So, I mean,
so
what's your point? That doesn't mean anything. Just saying somebody decides these things doesn't mean anything to me.
You almost got it. You almost got it. The point is,
Every
no,
objective
this
standard,
bullshit, you
though.
almost got it. You
almost got
don't got it. One more time,
almost got
I'm
it.
going to ask you, why
almost
can't you have
have
an objective standard?
You
It's just
almost
because
have it.
somebody else is making the rules. It makes no sense.
you almost have it. So standards need
Answer
to be
my
applied.
question.
I'm answering it. Standards need to be applied to circumstances, and your standard might
No.
be. No, standards don't need to be applied to circumstances.
So, I said so.
So if you're applying a standard like no overly disruptive religious displays, what the hell is that?
That's
right?
vagary. Your intent, what you're doing is you're intentionally being vague when I'm asking you for objectivity.
I'm
And
purposely
it's
making
bullshit artistry, right? You're like,
I'm
if you were to give
so
a vagary,
stupid,
if you were to give a vagary, then I would have a vague answer. Well, I'm not asking about vagary. I'm asking about specific objective standards. And you're saying we can't have them, and I need you to explain to me why the fuck you can't have them without using vagary.
You're not letting me finish my statement, and it's going to be hard for you to understand it if you don't let me finish it.
Okay, I'll let you finish.
All
And
right,
you're
buddy?
going to give me nothing but vagary, I guarantee it. But go ahead.
I'm purposely giving, just like the originalist where I was questioning him about the dictionaries, you just don't understand what's going on. So maybe just shut up and wait for me to explain
I'm
it.
trying to understand.
So I'm purposely giving you a secular vague standard that you're going to hate. That was the point of me saying any sort of...
Why? That's not the point of what we're contesting. It makes no sense.
Let me finish, please.
What purpose? Answer my fucking question. I don't need to let you finish on things that have nothing to do with what we're talking
It
about.
has everything to do with it.
Run the fucking time clock.
Just answer it right, or I'm going to interrupt you.
So just like you can have secular, very vague standards, you can have a very precise secular standards, you know? No...
Yes, you can. Thank you.
No,
I agree.
but those are, you know, no garments above 5
Yeah,
inches.
absolutely.
No-
I agree. Yeah.
No crosses. No
Agreed.
you know, nothing
You
worn
can't
around
see
the neck.
That's the one. You can say
confused
you
with
can say
your
stuff about
application
dress,
of
but you
objective at this point
But
You
because
cannot,
at the end of it-
cannot preclude religious artifacts.
So we can have.
you
so
can
we can
preclude
have
religious
objectives. We
artifacts
can have
in
objective
specific.
standards.
Wait, you
I'm-
can, and I agree with BPF on this.
Thank you.
Can have objective standards in particular situations, the circumstances. So, for example, you can ban a niqab when someone's testifying. That is a circumstance where it is relevant what the religious practice is for a very good reason. And you are applying that subjectively as the judge, but it is on an objective standard because what you would do is you'd go, well, I guess what is objectively occurring here? We're looking at religious experience, like content during a specific, like based on a specific circumstance.
Yeah,
I'm
a
confused.
standard is something you apply, right? You
Yes.
elaborate the standard based on, you hate this word, Andrew, precedent, right? You have cases before. You didn't think that this was going to come
Why
up.
did you say I hate the word precedent? When did I express that?
You were mocking people who were citing precedent before.
Well,
Is that-
no. What I said was that this is common for lawyers to do. Was to
Cite
say
precedent?
precedent.
Wow.
Yeah.
I mean, that's a great,
That's
great
that's
observation, guys. for
Wait,
Andrew.
but how does
Lawyers
it equal?
cite precedent.
How does that equal me hating it?
You were doing it in a mocking tone. Were you doing it in a mocking tone?
How
or
does
not?
it equal me hating it? Can you answer my
When you do
question?
a mocking tone, would you
Can you
say
answer my
Oh,
question?
hating
for
something
fuck's
or
sake.
Yeah.
neutral?
How does it equal me hating it? Even if I mocked it incessantly, why would that mean that I hated it?
I assumed Maybe
Yeah,
that was wrong of me.
right. So don't make assumptions. Just go off what I say. Very simple.
What did you want me to say? If I said mocking, you would
So
take
one
that,
more
wouldn't you?
time, I didn't say anything about hating anything, hating precedent, hating any of these things. Don't build straw mans. Just argue against what I'm asking you,
So
which is
precedent
why
is
can't we
valuable.
have
Whether or not you think you have the
why
perfect
can't we
objective-
have objective standards?
whether or not you think you have the perfect objective religious test that's going to apply to every religious display and it's going to apply to every religious circumstance you can think of, there's going to be something you didn't think about.
Well,
And
then
there's
give
gonna
me
be
the example of that thing so you can demonstrate it so that then I'll understand.
Let me do the value and then I'll give you an example. Is that cool? And
Sure.
Let me finish my thought and then I can give you an example. So there's going to be something that you didn't think about that, I haven't considered whether this is profane. Oh, this is new. Oh, this is whatever. Or this has never happened before. And you're going to have to apply your standard, whatever that standard is, to come to a rule decision. And
What if
that
you
will
think
be.
about everything?
You think that that's possible? You think humans can think
Sure,
about
of
every.
course. Yeah, there's plenty of instances where we think of everything in certain isolated circumstances. There's no
Can you
doubt
give an
that that's
example?
true. Oh, yeah, sure. Like, let's just take a leaky pipe. It always leaks. You always have a pipe ready, and it's always fixed, and it always happens that same way every single time. Whatever it is, it's regardless of what it is, it's still logically possible that you would always be able to fix some certain situations. There's no doubt that that's true.
I think it's not reasonable.
It's
to say-
reasonable or not, it's still logically possible. So I'm asking you again, why can't you have an objective standard where you've thought about these things and so you
about
can
everything?
objectively apply them?
Where you've thought about everything?
Well, you thought about everything within the confines of this thing.
What is even the scope of everything with respect to religious
Well,
display?
regardless of what that is, why couldn't it be done?
It would be so long.
It wouldn't be impossible. That would be absurd.
You would need like a supercomputer to be able to.
No, you wouldn't need a supercomputer. That's
wouldn't you?
ridiculous. Well, because again, do you agree with me that it's,
Everything-
do you
know what
agree with
everything
me
is?
that within the confines of one thing that you can know everything about one thing?
No.
In our world, no.
And
Logically, I would say there's.
what do you base that on?
Logically, I would say like there must be a limit to everything, I guess.
Even every singular thing?
What do you think? I mean, do you?
Scope of
I
the
don't know.
word-
Andrew, I really don't know. I hadn't considered whether what.
Well,
whether
the
everything is defined in
the reason I make these distinctions is because I see what happens is guys like you like to live in the gray area. You like to take kind of edge cases and say, based on the fact that these bizarre things may come up as a possibility, we should set standards on all of the edge cases. And this becomes problematic for guys like me, Jebtan, probably guys like the bottom right of the panel, because we don't think that you're being really good faith even in the application of the law, that what you're doing instead is you're trying to push your own programming onto people by pointing out edge cases and saying that those always need to be considered within the standard, and they really
law have an
Well,
answer
hold
for
on.
all.
really
Wait,
don't
let
need
me
to be.
jump in. Does
Let
Christian
me
law
jump
have
in,
does
because
Christian
I was
law and
being
Christian
told-
teachings have an answer for everything? Does Christianity have an answer for everything?
No, let me jump in real quick
Wait,
because I
is
was
the answer
just
yes or no?
hold on.
No.
Yeah, I just said no.
Are
I
you-
said no.
Okay,
Just let me go.
okay. We're wrapping it up with
Nothing to
that.
do with my
no,
point, though.
wait, stop.
Nothing to do with my point.
Okay, Jeb, we're gonna throw it to you.
Yeah.
Sprout, do you still want to make your point? I saw earlier you were raising your hand. Then we're gonna look at wrapping up.
I asked Pisco the question, so that's
Okay,
all I wanted
Jeb,
to do.
Yeah.
You'll lead us in the wrap up then.
So I actually don't have a problem with what Pisco's advocating for the most part, which is just the principle of our law, which is that you should have standards so that when an edge case comes up, you're not totally in the dark. Because I agree with him that while maybe in some ethereal way it's possible we could have thought of everything in a case, it is practically not probable that we ever will in any case. So it's best to have standards and to rely on precedent when edge cases come up, and understand what seems to be blatantly against what we believe to be righteous and what is not. That's why the whole selective incorporation doctrine has the standard of if something is a fundamental right or not, and we have a lot of big fights over that. But that still is a standard, just because it's imperfect. That's why I think the standard in these cases, in terms of coercion, I think that as far as our objective standard for whether something is coercive or not, I think it should be considered, and it should be of primary concern, whether the person in question had a direct good faith attempt to express specific non-coercion and that there is no proof of unequal treatment based on whatever it was they were doing, in this case, inviting people to pray. I agree that in a locker room speech setting, there is no way you don't have coercion involved, because those students have to be in that locker room at that time, listening to that coach. They are not allowed to look away, they're not allowed to not listen, or they can be reprimanded. So I agree in the locker room setting that would be against the First Amendment. I think where Pisco and I disagree is I believe I think my standard is higher than his for coercion, and I think as long as there's a good faith attempts to express non-coercion and there's no proof of like material.
The conversation was okay before BPF joined. He's
He's
just a fucking cunt, you know.
I understand it doesn't for Pisco, but I don't think he's being weaselly.
Like he's just a
and I
pointless
understand the value
wanker.
in like the general legal principles that he is.
Like I disagree with loads of the other people on the panel, but they don't appear to be like
Okay, we're
absolute
gonna wrap
lunatics.
up now. Everybody's gonna give their ending statement, and also they're gonna shout out where people can find them. Thank you for a interesting roundtable, to say the least. We're gonna start with More Perfect Union.
Yeah, thanks for having me on tonight. I do appreciate it. It's a lot of, I think, good discussion, and it clearly, there's a lot of people who think that they disagree with the court based on what they feel. I put myself in that same group, right? I believe that what was done with the Second Amendment case was valid. Pisco and others have argued that no, it's not. They don't agree with the holding, right? The same thing with the religion case. I agree with the court's finding that this was this person's private expression. The fact that other people happened to be there, and that they chose to participate voluntarily, that he took an affirmative step to ensure people knew or understood that they were not being coerced to do it, that there would be no penalty if they didn't choose to participate, and also the finding that what was it? That part of the case that was before the court was relied on a test that was under the Lemon case, and they said that was largely debunked, right? So I'm totally okay with the way the Supreme Court did it. I think that there are reasonable limits in terms of circumstance where people are expressing their religion from a work perspective, which gets into the thought and theory of like indoctrinal content. And there are a lot of reasons to be against indoctrinal education for a lot of reasons that probably are going to come before the court in the next couple of years anyway. So we'll just have to wait and see how it goes. But in this case, I think the Supreme Court did it right. I do find it interesting that everybody who is on the left side has been, the Supreme Court's bad, Supreme Court bad, but they were totally good with like the reasoning behind Roe, and Roe arguably was bad legal doctrine, including from RBG herself. So you guys take it away.
Okay, I'm gonna throw it over to Sprout.
Yeah, I'm the Sprouticus. Thank you for having me on tonight. You can find me at twitch.tv/thesprouticus and twitter.com/thesprouticus. I'm just genuine. I honestly don't know where I stand politically anymore, and I'm just a genuine guy who's going to give a genuine take. And so if that's what you enjoy, come watch me on Twitch and come follow me on Twitter.
Okay, I'm gonna throw it over to Pisco.
I think proper application of legal principles to this case makes it clear this is private speech. Government speech, and so it's therefore not protected by the operative amendments. And even if it were private speech, the Establishment Clause would prevent any sort of problem with respect to the school's conduct. I think that's clear. And to sort of also another factual matter that was brought to my attention, it appears that the guy quit. He wasn't fired. Someone DM'd me that. I might have misread that part, so I think he actually did quit. So on that point, I'm sorry that I misinformed the audience. On this whole sort of back and forth that we had with Andrew about like standards, when you can have a perfect objective standard. I mean, he's just like stupid on this. We live in the real world. We have to have people who look to different standards in books. We have to have, we don't have supercomputers to think of every possible factual circumstance. And in the real world where we have consequences, there's going to be gray areas. That's why we entrust certain people. That could be a minister, that could be a cleric if he wants it to be a cleric. But to try to search for pure objectivity, if that's even possible, I think is futile in this world with human frailty as it is, and even the admission that his own, I think, preferred theology, Christianity, doesn't solve all problems. So we're going to have to look to non-Christian sources to solve things that Christianity doesn't solve. And so in every aspect of human endeavor, you're going to need to have standards. That's just a fact of life. And he might not like our current legal standards. He might not like our current political standards. Good luck changing them. But really, really good luck on trying to avoid having any standards at all.
Okay, next I'll throw it over to Andrew.
Yeah, so I don't even know what the hell this guy's talking about, right? Good luck having no standards at all. Nobody advocated for having no standards at all. Good luck changing the system. Well, we've already been changing the system. That's why we're here on a panel yelling at each other, right? It's because the system was changed and liberals are pissed off because the system got changed. So the good luck changing the system thing makes no sense and is completely irrelevant. My point for this portion of the panel was that this particular case is kind of irrelevant in the larger scheme of things, but rather to try to test the consistency of the people who were saying the things that they were saying to see if they measured up as a standard that we could go by or not go by. And they're not. This nation is highly fractured, and we know it's highly fractured. We have tons of different worldviews, and they're always competing in the arena of ideas. And that's the way it was set up. I hate it. That's true. Pisco got that right. I do think that we can have better standards for these things. More importantly, try to understand that when Pisco says these things, he doesn't say them because they're not logically possible. He says them because he says, well, within the real world, they can't be done, which doesn't mean anything. Yes, they could be done. If it's logically possible, at some point, perhaps it could be done. Even right this second, right? We have no idea whether that's true or false. We just know that at least it's possible. So this is all I was doing. So I did jump in the panel a little late, and I did do a little bit of shit posting because I think that it's good to fire fuckers up to not have a completely boring and irrelevant debate. But I am saying that the right wing does suffer from a consistency issue. There's no doubt that that's true. The left is a little bit more consistent in their beliefs, and the reason for this is because, well, the left thinks that almost everything is permissible. It doesn't matter what it is. They generally put no limits on behavior. They generally put no limits on anything short of, like, you can't stab a guy in the chest. Other than that, everything goes. So it's always harder for the right to justify everything that they do because the whole point of the right is conservation of thing. That's what conservative means. We're trying to conserve something. Well, in this case, what are we trying to conserve? I'm not trying to conserve some fucking public school bullshit. I don't care about public schools, and I don't care that the public school is trying to conserve the art of prayer or not conserve the art of prayer. Totally irrelevant to it. It's not the conservation that I ascribe to, and for the most part, I think that it's kind of a useless conversation in the end because it's just a bunch of lawyers who are going to get together and tell you what's good for you. So, in the end, I'll grant the left, they are more consistent just because they believe in less as far as limitation. In the right, unfortunately, most of them don't even know what the right wing is. They could never point to anything they actually want to conserve. So that's how I'll end this. You can find me on The Crucible, and I hope you enjoy the debates we host there.
Okay, next I'm going to throw it over to Jeb.
Yeah, so point of clarification, because we mentioned he was suspended earlier and then the he quit thing came in. It's sort of complicated, but not really. Basically, coach was suspended, paid administrative leave, because it was nearing the end of the school year, or end of the season, rather. And then the athletic director suggested he not be rehired, so he simply just didn't apply again because he knew he would not be rehired. So he was effectively fired. Like, it's not that he quit. He didn't apply again knowing that they were not going to welcome him back. I think I said most of what I needed to say. I think the primary point of disagreement between me and Pisco, which is the one I had the substantial back and forth with, is just the standard at which coercion applies. And I can acknowledge that there's a possibility, I'm not certain, that my standard might be a little tighter than some precedent before, and that the the coaching questions lawyers might even agree. I still think that should be the proper standard. I think it makes the lines a lot cleaner, and it serves for better and more consistent logic in this particular case regarding the freedom of religion and if he was free to do this stuff. I guess as a final note, to throw a bone to the more left-leaning people on the panel, the third topic was going to be about the Remain in Mexico policy ruling. I 100% agree that power is totally right to be given to the executive branch because that's how it was laid out in the first place. And although I think Biden shouldn't have decided to revoke the Remain in Mexico policy, because I think it was a good policy, he has the right to do so. So that'll be my finishing off on agreement. I'm Jebtan, Jebtan on Twitch, and Jebtan RIP on Twitter. If you're only going to follow me on one, do it on Twitter, because I don't stream a lot.
Okay, next is going to be Kevin Logan.
Yes, I'm actually going to agree with Andrew on one particular point. This was a rather pointless conversation. The problem is he's the reason it was fucking pointless. His constant interruptions and non sequiturs and sidetracking were fucking tedious. Honestly, we were having a vaguely productive conversation before he joined. I was actually quite enjoying it until he decided to encroach upon us all. But as to a point he raised earlier, where does it say in the Bible about peacocking your religion? I'll give you the direct quote. Matthew 6. When you pray, you shall not do as the hypocrites, for they love to stand and pray in the temples and in the corners of the streets, that they may be seen by men. Most certainly, I tell you, that you have received their reward. This man, he didn't want to listen to the Bible quote.
You scared him off.
Oh, what a terrible Christian. He doesn't want to hear from Jesus on the Sermon on the Mount. What a fucking wanker. Anyway.
This is public speech, Kevin, okay? Keep the Bible out of it.
True, I am being paid by a school right now. Anyway, you can find me at KFLogan1875 here on Twitch, or quoting the Bible randomly and then scaring Christians away. Peace.
Okay, next I'm going to throw it over to Ginger.
I am Ginger. You can find me at twitch.tv/GingerRemoth. I do cosplay and mostly gaming. To sum up my opinion on this, I feel like they weren't hypocritical.
I can't believe you ran away, you little bitch.
Allowing him to win. But I do feel like
rage quit by
the only
Jesus.
reason that they aren't is because they still do have the Pledge of Allegiance in school. And
chalking that one up in the W column.
Or they do have the kids that will recite it, which is specific.
The power of the word of Christ.
And it gets confusing when they.
The power of Christ compels you to rage quit.
But I do feel like he was peacocking, and he should have kept it to himself. There, you can pray in privately just as well as you can pray in the middle of a field. So again, that's Ginger Remoth on Twitch and Twitter.
Okay, I'm now going to throw it over to, I think everybody but Franklin's gone. Franklin, yes. Wrap us up.
Hey there. Yeah, I think that this illustrates a good point about the law in that people read a headline and they get pretty, excited about it because of the outcome of the decision and whether or not they agree with it. They don't really look at the old precedent very much. I'm not sure how many people read all 4 cases, but it was a lot for anyone. I normally read at least like 10 cases, maybe every 2 days, and it was still a lot of information to, pick up and then read all the other precedent that would be relevant to it. So I think it is very difficult that a lot of people don't know generally what the law is on an average basis. And so even Mr. Kennedy in this case wasn't really sure what the law was at a particular time. I do think he took a good opportunity to ask. I do think he did, with his behavior, slowly start to pull that back and not engage in that behavior. The school was okay with him praying at night after the games. He did that for a little bit, and then eventually it seems like the school might have dismissed him. Obviously, they were very concerned with the establishment clause. I think that's 70 years of precedent just down the drain. And I think it's really awful that Gorsuch basically killed it without saying that he killed it. I think that's the problem with this new court, is that there isn't really any way for you to know what exactly is gone and what exactly why they're doing it, because they're not applying stare decisis and they're not explaining why they're getting rid of these old precedents that they think seem to be negative but don't give any explanation. So yeah, I'm Franklin and Slash. I talk about the law. I have conversations with people. Sometimes we talk about weird things that make it scary for people. And yeah, I just like to have fun. So come over and check me out, and I'll probably crush some more beer. Thank you.
Fantastic. Thank you all for coming on today's show. I appreciate it a whole lot. It certainly was interesting, and I appreciate it. You all have a blessed weekend, and take a few, like, pop a pill or two for a headache. Okay? You all have a good one.
Thanks a lot.
Thank you for having us.
See you all.
Well, that was a thing, wasn't it? Wasn't it just? Hang on a minute. How do I... Hang on a second. Come on now, Kev. We can sort this out. We're big boys here. Come on. Oop. No, where are we? That one? There we go. Someone did a meme. The power of Christ compels you to rage quit from Hippy Dippy like a biatch. Boom shakalaka. It's true. It's a fact. Why is there always one asshole on this planet? There has to be. I think there's like a quota. I think they have to meet a quota. Anyway. Well, that was a whole ass thing, wasn't it? I can't believe I got him to rage quit because for Jesus quote, that's pretty special. Definitely chalking that one up in the dub. Massive dub column. Can we get some dubs in chat? Let's go. Okay, we had bits and things happened. We heard voices? Fuck's sake, noises. Thank you, Rosa8472 for subscribing on YouTube. What's this? Okay. Thank you to Belfour P with 501 bits, presumably a reference to darts, I imagine. Good night, you fantastic person. Thank you, Mr. Logan. Well, presumably you're in bed then, but thank you nonetheless. Oh, fuck me. Gassy. Thank you, Spongy Lord with 100 bits, who says, every day the collapse of the above-ground world grows closer, and in this dramatic and climatic twilight, human civilizations with civilian jets, the mole people will only grow stronger. Even the bombs will not reach our dens. When the sky above you rains hell, look to the Mother Earth and her warm caverns for safety, and you'll find us. Well, yes, thank you. Yeah, the mole people. It's the only answer, okay? Mole people. Honestly, getting him to quit was fucking delicious. Very, very happy with that. Thank you, Spy Guy, Canadian Glasses, Somniote, Your Boy Heavy T for following. Welcome to the Kevolution, one and all. Thank you, Dr. Lewis with 102 bits, who says resuscitation bitties. Oh, that was when I was saying that I'd lost the will to live. Which, you know what? Never before has a quote from Jesus, not since I was about 12 and still believed in that shit, has a quote from Jesus made me feel better. It's very rare in modern times that a quote from Jesus makes me feel good. But you know what? Sermon on the Mount, absolutely love it. Blessed are the cheesemakers. We're close to a hype train, as if that's happened this late. It's fucking 25 minutes past 4. Where was I? There was another thing. There were other things. Where are I? Thank you, Dank Prol with 180 bits, and thank you, Wayward Historian with 667 bits, which is the neighbour of the beast. Definitely. Wow. Where do we even begin? I suppose I can just say, if you're new here, if you've come over from the Hippy Dippy, cheeky little hit the follow button. Just, follow button's not going to hurt you. In fact, the follow button is very much your friend. You should smash the shit out of it. Like Shinzo Abe's back, absolutely smashed the shit. Sorry, too soon. Yeah. God. Like he literally just went in there and he was like advocating theocracy. Like, so what's the point of even talking about like legal precedent or anything like that? You obviously don't give a fuck. You just want a Christian theocracy. And he got butthurt that I called him a Nazi, even though he's an authoritarian who wants to enforce religious doctrine. Kind of like a Nazi, really. You know. Crazy talk. Kev, is that your Chud Logic impression, the flashing eyes? Well, it's not my impression as such. Someone made that for me. It's one of the emotes. It's one of the emotes. If you hit the follow, hang on, is that one of the follow emotes or one of the subscribe emotes? I can't remember. I don't really care. I think the American war propaganda made them too good at being zombies. Was supposed to be good for military, but not ruling the country though, obviously. Yeah, a little bit, I think, probably. Yeah. It's a channel/follow emote, so you don't even have to be sub to use it. Exactly. Well, if you want to use the green eyes emote, just hit the follow button. If you wanted to, it's not a problem though. It's like how he hated being accused of being a Catholic. Nazi is the wrong flavour of fashion. I suppose so. Yes. Yeah. I mean, there were Lutherans who were Nazis. Like, there were Catholics, like Hitler, for instance, but there were also a lot of Lutherans, a lot of German Protestants. I prefer YouTube emotes over Twitch. Can you personalise emotes over on YouTube? I don't even know. I've no idea. Well, thank you, Makuzia, with 2,000 bits. Much love. That is very generous. Yeah, and now means I have to stay longer. Because I can't leave in the middle of a hype train. Although, really old frogs on the channel will remember the very first hype train I ever got on the channel. I left halfway through because I didn't know what the fuck it was. It just said, oh, the hype train has started. And I was like, okay, what the fuck's that? I don't even know what that is. Oh, hello, your boy Heavy T. You're James from the internet. Frog. I don't know why I'm saying frog now. That's a thing that I've been saying for ages. What the fuck? Yeah, James is fucking dope. I suppose BPF just wants to be an American fascioid and not compared to a swarthy German fascioid. True. Very true. But it was actually disappointing, like, because the first conversation, right, it was okay. Like, it was sort of dumb because it's full of conservative shite, but like, it was a vaguely productive and worthwhile conversation. And then that wanker steps in with his scientism and just, oh God, what's the point of his existence, honestly? A genuinely worthless creep. Very disappointing. What can you say? Post-scarcity society where we no longer have to worry about politics. And then Chad. What? I don't know. White Strike, you're not making any sense, friend. I don't know what you're talking about. Oh, let's check how many notifications on Twitter. Oh, 1 million. That's what happens when I don't check midstream. Yeah, the fact that I got BPF to rage quit is definitely good meme fodder. I think that'll do the rounds. That's good. Might even make the clips of the week thing. Danabo does. BPF was the token immoral guy. It's nothing yet. I don't even think he's just the token immoral guy. He's just a wanker. I got tons of clips of you tonight. Oh, good. I'm glad, Mr. Braindead. I am glad. They should introduce religious studies in the US. It might shut up the Christians about evolution and teach a little tolerance. Well, that actually, the religious education stuff is good. Religion is a part of, like, human existence, and you should know about these things. It's interesting to learn about different cultures and stuff. But when BPF says, like, stuff like religious education, he means teach my ridiculous, like, young earth creationist fucking bullshit version of religion. Whereas actually, you should learn about everything. You should learn about all different types of religious beliefs. Like, I remember learning at school. Like, I went to a Catholic school, right? But under British law, you have to do, like, when you do religious education, it can't just be you teach this fucking thing, right? You can't just do religious proselytizing. You have to actually teach about religion. And I remember learning about the 5 pillars of Islam and all of that. And I was like, oh, that's actually interesting. I've learned something. I've actually learned a thing. What's this? Andrew, on one particular point. This was a rather pointless conversation. The problem is, he's the reason it was fucking pointless. His constant interruptions and non sequiturs and sidetracking were fucking tedious. True. The fact that those in power right now don't consider evolution to be religious thought is the end of the discussion. Because if it's just about power, they've made the decision. Memes. Thank you, Mr. Braindead. Anyway, yeah, sorry, I was saying about religious education. If you do, if you learn about different things, like, that's one of the few times in school where I felt like, oh, you're actually teaching me something interesting about the world here. That's good. And I know, like, that was like a childish way of viewing it, because when they were teaching me mathematics, they were also teaching me something new that was good and useful and all the rest of it. Although they also did teach me algebra, which I've obviously never used, because it's nothing. Fuck you, algebra, you dickhead. Anyway, but the point is, like, I was genuinely fascinated by that. I thought that was really interesting. But like I say, when BPF talks about it, he's not talking about religious education, he's talking about religious indoctrination. That's what he wants. Thank you, Wayward Historian with 1,000 bits, who says no comment, which we've been through before. Writing no comment is a comment. You're being tautological, goddammit. Is it tautological? Is that the word I'm looking for? I don't even fucking know. I'm just angry. Actually, I'm not angry at all. I'm very happy. I genuinely, before he rage quit, like, this is why fascists never get the idea. And look, I'm just going to call him a Nazi because that's what he fucking is, okay? He can be as butthurt as he likes about it. He is. That's what they don't get. Their fucking insistence on, like, not hearing an opponent point of view is just, that, for me, that works. Like, that was the biggest W I could have hoped for. I was just going to kind of make fun of him, point out the religious hypocrisy of it, and then, like, move on with my life, like it wouldn't have been a problem. But I'd come away from it feeling a little bit deflated, just on the basis that, like, the conversation was pointless and shit and a waste of fucking time. Whereas now I'm like, you know what, actually, I'm buoyed by that. I'm buoyed by him fucking off. Beavers gnaw down 40-foot wooden surveillance pole in the Wallonie Forest in the city of Atlanta. We saved some leftovers for you on the side of the road, what it would appear the piling mount of broken surveillance cameras. Fucking based, comrade, beavers. Fuck yes. Go on, Nick. Nick knows all about the awesome animals and shit. My phone kept cutting out. Okay. So, I mean, that's a shame. But, I mean, don't watch it on your phone then. Watch it on computer or something. I don't know. I don't tend to do a lot on my phone in terms of watching stuff. In terms of, like, YouTube or whatever. Yeah, BPF, look, to be honest with you, it was probably more entertaining, maybe, because a shit show is always worth a watch, I guess. But in terms of it being a proper conversation that meant anything, it was fine until he joined. Like, it was a vaguely worthwhile conversation based on, like, law. That's why, like, I didn't want to interrupt the lawyer guy, because he was actually making good, interesting lawyer points. Like, when you're talking about legal matters, having, like, a legal... Like, I'm not going to say he's an expert or whatever, but, like, he's a trained lawyer. He's a trained lawyer. And having someone in that position... Also, it was good to see BPF get BTFO'd, ironically, when the guy literally bought his fucking legal degree out and he was like, oh, fucking nerd. Like, absolutely ludicrous. Anyway, but yeah, when you've got someone who has, like, an actual expertise of some variety in the area and can talk you through particular points, let them talk. Like, that for me was far more interesting to just shut up and listen to the lawyer talk about law. You know, that for me is a much more interesting thing. It's a shame like I say, it was a shame he was talking to BPF, because that guy's a fucking idiot who clearly not only doesn't understand the law, but doesn't want to understand the law. He has no interest in understanding the reality of all of this. He couldn't give a shit. Honestly, he couldn't care less. I think people have issues understanding what a funny shit show is and just what shit show equals content, when a lot of times exhausted and unwatchable. That's kind of true to an extent, but you've got to bear in mind, even a kind of pointless shit show, people will still watch it, even though, like you say, it's unwatchable in theory. People will still watch that shit. I've said this before. People will complain about the content, but they'll still watch it, right? And I'm not saying you specifically, X-Ray, but whoever, right? People will talk about the standard of content on, like, YouTube or Twitch or whatever. If you're still watching it, you're feeding the algorithm. The reason that things get big like that is partly because of, like, dark money pushing it to a certain extent, like advertising from PragerU, or what they try to do to fucking AstroTurf Abby Shapiro or whatever. Like, there's stuff like that. Or the fucking, you know, they're trying to push what is a woman, that fucking manufactured consent bullshit. All of that, right? Not manufactured consent. I read that from the chat. Sorry. That kind of constructed, like, want or whatever, that constructed market. But generally speaking, if people watch a thing, it boosts the algorithm. That's why those things become what they are. The viewership is there. People want to watch it. People continue to watch it, and so that's what gets pushed. So even though in theory it's quote-unquote unwatchable, and I agree, people watch. People will watch that shit. You missed a shit show last week during Charmhole's first panel. Oh, Charmhole. Fuck me. God almighty. Ugh. He is a person, isn't he? Technically. League of Legends is a wildly successful game despite it being a player base agreeing that it's a total hellscape. Yeah, I guess. That's part of the fun, is complaining about it as well, isn't it? Anyway, fuck it. Right, I'm done. Yeah, Charmhole is a fucking dildo, correct? Yeah, it's 4:40. I'm going the fuck to bed. Right, who shall I raid into? Who is currently streaming? Polly's going. Anyway, if you enjoyed whatever the fuck this was and you want more of me, there's plenty of Kev-Kev to go around, is all I'm saying. You can hit the follow button, you can subscribe, you can do all of those things if you so wish. And I would be greatly appreciative of that. Where's Polly? There she is. Go and say hello to Polly, who is fucking based as fuck. Anyway, I'll be back. I don't know if I will be back later today. Maybe I will, maybe not. Either way, at some point in the next few days, I want to watch the Jordan Peterson video because it's so fucking wild. That guy is the saddest human being that's ever lived. Anyway, thank you all for listening and watching. You're fucking amazeballs. No pass around.